any, my lord, date leak, it may be not.
You have applied for vacating.
Yes, my lord, I have applied it, my lord.
You have
Because-
applied for vacating.
Yes, my lord, 28th, my lordship had fixed it.
Application filed for
Yes,
vacating.
yes, my lord. I have filed it, my lord. 28th, my lord had given the date also, my lord.
As to date 25th was the date taken up.
Okay, yes, my lord. 25th was the
Yesterday.
date yesterday, my lord.
Yesterday matter was there in the list,
Yes, my lord.
but it could not be reached.
Yes, my lord. So only submission is resort accommodation either today, tomorrow, my lord. I am not really burdening this honorable court, my lord.
Bank account has been attached.
Attached, my lord. It was client bank account, my lord.
You are mentioning upon notice.
My lord, we will mention. We will give the notice, and my lord will.
No.
We will come at.
Very well, very well. You give notice and mention tomorrow.
Okay.
Tomorrow, today at 2 p.m. my lord.
Mentioning at tomorrow.
Okay.
Mention the matter tomorrow. Then I will see what can be done.
Yes, grateful, my lord. Grateful.
Mention upon notice tomorrow.
Grateful.
My lord,
Yes.
may I have your lordship's leave to mention a matter for inclusion, my lord? There are two GAs in the matter, my lord. One is for taking on record documents which have been admitted inter se between parties to be marked as exhibits. The other, my lord, is for appointment of advocate commissioner, because the witness, my lord, in course of the examination in chief has been indisposed because he's an employee of a construction company where he is required to be at site. So the other side was also agreeable, my lord, before the...
So two applications are there.
Yes, I am mentioning upon notice, my lord.
So to be new motion day after tomorrow.
Grateful, my lord.
No, day after tomorrow is Friday. Huh? That's Monday.
Any my other side is also present.
Monday new motion.
Grateful.
দুটোই নিউ মোশনে দিয়ে দাও মানডেতে।
May I be permitted to mention one CS Com 587 of 2024, which was supposed to appear on yesterday.
For hearing.
Well, under the heading witness action. Well, is the
so mention after January.
Well, it was fixed.
Maybe you can, if you ask, I can release it. No issues. I have no problem. But I cannot fix the suit now. Whatever is there in the list, I have to follow the list. Then.
Item number 1. Lordship, I appear on behalf of the.
Why?
Lordship, this was in between the same parties. My lord had already
release.
This one section 9, which was assigned to you.
No, I have to release.
Yes, sir.
Ashun. This interlocutory application and the suit stands released from my list, comma, on my paragraph. The records are directed to be sent forthwith before the Secretariat to the Honorable the Chief Justice for taking steps for assignment. Hey, Baba, এটাকে একটু ঘুরিয়ে দিতে বলো তো তলার থেকে। দিদি একটু তলার থেকে এটাকে জাস্ট বেস থেকে একটু ঘুরিয়ে দিন আমার দিকে। জাস্ট বেস থেকে। হ্যাঁ, আর একটু করুন। বাস ঠিক আছে। থ্যাংক ইউ।
I'm grateful. New chamber application. Item number 2. National Court versus the State Judge.
Application for
amendment.
Amendment of
Very
claim.
ministerial. Very ministerial, my lord. What happens is this was.
Take the microphone. Where is your other side?
Other side, my lord, hasn't appeared as yet. He hasn't appeared as yet.
No interference.
No.
Time to file
just
statement gone.
No. Just, my lord, which has been admitted. Kindly have a look at Justice Rao's order.
But where is your other side? Have you served?
Master summons, my lord, I don't think, my lord, it has been effected on them. So, I am quite sure, my lord, it hasn't been effected on them. The order, my lord, your lordship would see.
They appeared in the suit. They entered appearance in the suit. Time to file written statement stands
there,
forfeited
No, no, my lord,
from the
because
date of writ of summons, service of.
my lord, they haven't appeared. Summons is, the writ of summons hasn't been lodged as
So where is your affidavit of service for this application?
this application, my lord, we haven't served this yet.
So kindly serve and come back.
But we were under the impression, my lord, that since, my lord, it is even before, my lord, the service of, my lord, the summons, it could have been done
No,
even
no.
without.
Next. Ashud.
Do we
This
think
is
that
an
should,
Mr. Aniruddha Chatterjee, then a senior advocate, appears for the plaintiff oblique applicant. Paragraph. This is an application seeking amendment of plaint. Full stop. Paragraph. None appears for the defendant oblique respondents. Paragraph. The applicant shall serve paragraph. Applicant shall serve notice upon along with a copy of this application upon the defendant and file affidavit of service when the matter shall be taken up next. Paragraph. The matter shall appear under the heading New Chamber Application on December 16, 2025.
grateful, Your Honor. 2 and 3, my lord.
Huh?
2 and 3, same.
You are appearing for this same. 2 and 3 same order. That is also for amendment. All right.
You know, put this item number 4, you put the rent of private limited.
I have an my suit, my lord, there's the GA1 with my application for security before judgment, my lord. 11. My GA1 is for furnishing order 38 rule 5 and injunction. My lord, that hearing was stulted because they filed an application for revocation of the leave granted under 12A, which was heard by a coordinate bench, rejected, review has been filed, which is pending. That is before the coordinate bench, my lord. Then an application under section 8 was filed, which was heard in part by the coordinate bench. Now it is, now it is being heard again. It has to be heard.
The moment they filed section 8,
That injunction got held up.
no, the moment they filed section 8, they admit that the 12A is perfectly done. So they cannot raise any objection without with regard to grant of dispensation. 8 has to be heard.
8 has to be heard now. So these are all dilatory tactics to defer the hearing of my GA1. Now, Mr. Banerjee had commenced his arguments. Today, I'm told he's in some difficulty.
Today and tomorrow, Mr. I have
No,
mentioned.
no.
This matter was fixed. It came in the list and then it was fixed for today.
No. Before me or coordinate bench?
Before your lordship, it was appearing in the list as serial 53 on
Your
the
lordship,
particular date.
It
and
came on 13th of November when your lordship has fixed today.
Fixed today.
Thereafter, subsequently, Mr. Banerjee had
No.
some difficulty today and tomorrow. I mentioned the matter. Then your lordship has indicated that to renew my prayer at the time when the matter is being called.
Day before yesterday, they mentioned the matter, but this was fixed long time in advance. A fortnight back, it was fixed. And I am suffering because my GA1 is being held up, my lord.
It was mentioned on 19th of
Proceed.
Lordship, it was mentioned on 19th of November. It was mentioned on 19th of November. The order was passed on 13th of November. Mr. Banerjee requested he has some difficulty only for today and tomorrow. Any day, your lordship, he will argue that.
Paragraph. Ashok. Mr. Krishnaraj Thakkar, then senior advocate, appears for the plaintiff. Full stop. Mr. Rudrojit Sarkar, learned advocate. Mr. Krishnaraj Thakkar, learned senior advocate, appears for the plaintiff. Full stop. Paragraph. Mr. Rudrojit Sarkar, learned advocate, appears for
Defendant number 2 and 3.
defendant number 2 and 3. Where are the others?
I am here the defendant number 1.
All right, wait. Mr. Jishan Hawk, learned advocate, appears for defendant number 1. What about the others?
Those are not appearing.
Paragraph. None appears for the rest of the respondents. Paragraph. Which is the one today appearing, sir?
My lord, both
Both GA1 and GA2.
GA1 and GA2.
New motion.
Yes, my lord.
It's GA2 is appearing. Why?
That-
Where GA1?
GA2. I'm sorry, your lordship had directed on the last day that after GA2, which is the section 8 is disposed of, then your lordship will hear GA1. I stand corrected.
Paragraph. IAGA1, IAGA-COM 2 of 2025 is an application filed under Section 8 of the Arbitration and Conciliation Act 1996 by the defendant number
2 and 3.
2 and 3.
2 and 3. Full stop. Comma. This is fixed for hearing today. Paragraph. Mr. Rudrajit Sarkar, learned counsel, appearing for defendant number 2 and 3, prays for an adjournment on the ground that the learned arguing senior counsel, Mr.
Ratnanko Banerjee. Mr. Ratnanko Banerjee.
Ratnanko Banerjee, has some difficulty today and tomorrow. Has some personal difficulty on today and tomorrow. And accordingly prays for an adjournment. কিভাবে শুরু করেছি? Mr. Rudrajit Sarkar. No. And accordingly now, full stop. Today and tomorrow, full stop. Paragraph. Mr. Thakkar submits that unless the Section 8 application is disposed of, his application is stuck, comma, seeking attachment before judgment and the consequential injunction. Full stop. Right?
Yes, please.
Paragraph. In view of the above, the matter shall appear under the heading new motion on
But at
आगे
your-
कहो तो नहीं?
Today we are 26th, my lord. Is 28th convenient, my lord? Friday, yeah, my lord. Matter only. Of
December 3, 2024, 2025.
Great. Your lordship will kindly, my lord, on that date, kindly permit me to appear on the virtual mode, please, my lord. Your lordship allows virtual mode.
Yes.
Kindly permit me on the virtual.
But it is always a
Yes.
pleasure to hear all of you physically.
It's just that I don't want to delay the hearing, and but I have some other outstation commitments, so my lord, I'll be there.
Fourth,
No,
let's
can
say.
third, my
No,
third,
no,
fourth,
I
fifth.
tell you why. Because again, if you are stuck, then
No, no,
again on your ground
no,
adjournment.
No, my lord, no adjournment will be sought, my
All
lord.
right.
My learned
Wait.
third, my lord, kindly keep it on third.
December 4.
My lord, they will not finish, my lord. I'll tell your lordship.
six.
They will take 3
Let me
days.
see, let
No,
me
no.
see.
My lord, they will take 3 days, my lord.
That I don't
No,
know.
no, no.
Let me see.
Third,
How do you know? They may
Hey.
take 15 minutes.
no, my lord.
All right.
Application is very
Fourth,
short.
fourth,
The third kind.
fourth. You have difficulty on fourth.
Third, fourth, fifth, all 3 days. Kindly keep it on third, my lord. Somebody will be there to argue, my lord. I will be there virtual, but kindly keep it on third, my lord. Because otherwise, client is really suffering, my lord. Otherwise, I would not have made.
Third,
I'm so grateful, my lord. Deeply.
December 3.
Order. Item number 5.
May it please, Your Lordship. My Lord, this is that matter which was being argued.
Yes.
My Lord, may I only pray if, my Lord, both the matters have to be heard analogously, no doubt, my Lord. My Lord, if this may retain its character as a commercial matter and the other as a non-commercial matter, let them be heard analogously. But while retaining, my Lord, the character of both the suits. This being a commercial, that being a non-commercial.
I
retain-
indicated you, I'm not going to convert.
My Lord, I'm very grateful. Very grateful.
What's your instruction?
I'm, my Lord, with my Lord, one protection, that is, my Lord, what is our, my Lord, concern is that with those two orders which I had handed up, their chance to file the written statement is closed.
Sir, as it is, it will be taken up from
Very good.
today,
Very
where it stands today.
Very, very grateful.
Yes, madam.
I have to take
Take microphone.
I have to take instruction, my lord, from my senior, my lord.
No. I appreciate. This I will not put the gun on your shoulder. Don't worry. I'll put it on your senior's shoulder. Not to worry. Very well. I'm keeping it on some other day. Little research work you do. In a commercial suit, how far court can exercise its power under 151 of Civil Procedure Code? Inherent power.
It can, Lord, I'll tell.
Of course it can.
Because of section 16, my lord. Because section 16,
of course, it can
it has not keep changed, my lord,
in
151.
view the purpose of the act, enactment.
Indeed.
That I know.
Because of section 16, it is always there.
Always, absolutely, and not only that.
Whenever your lordship feels, my lord, with a 151 for ends of justice, my lord.
After all, I am sitting in a proper civil court.
Indeed. Nothing shall be deemed to limit or otherwise affect the inherent powers of the court. For ends of justice or to prevent abuse of the process of the court.
Yes, where you have read?
My lord, I'm reading section 16
Yes.
with the schedule. First, section 16 of the Commercial Courts Act, amendments to the civil procedure in its
Then where
application.
is the schedule? I don't get the schedule.
Schedule is immediately after section 23, my lord.
Section?
After section 23, may I hand over, my lord?
No, one second.
After section 23, my lord, is the
schedule.
In that schedule, a lordship will find there is no amendment to section 151.
Kotha. Schedule which entry?
No, there's no entry. That's what I'm submitting, my lord. There's no entry amending 151. So first is amendment to section 26. Number 2, my lord. Second is the substitution of a new section for section 35, that the costs provision. 3 is, my lord, amendment to 35A. Then amendment to the first schedule. Order 5 is being amended, my lord. Order 5, Rule 1. Order 7, Order 8, Order
I'm not
11.
on that. I'm not on that.
Yes,
Kindly
but
take
thereafter-
the language. The provisions of Code of Civil Procedure
My lord.
shall in their application to any suit in respect of commercial dispute of a specified value stand amended in the manner as specified in. So
Indeed.
except the amendment,
Except
the
I'm
entire
very-
code applies.
Exactly. my lord. So 151 is not touched upon.
Absolutely.
That's the answer. my lord.
And keeping in view the objective of
the-
legislation.
Indeed. That's why, my lord, I bow down to what is followed
And
from
there
your
the
lordship.
Ambalal gives an answer to that. Your
Paragraph
Ambalal,
13 and 14.
Ambalal gives an answer to that.
13 and 14.
But still, madam, you do some research work. If you get any judgment, bring it on that day. And have you understood what point you have to take instruction on? I will transfer this civil suit, not transfer. I will direct this commercial suit to be heard along with the pending ordinary civil suit.
My lord, as commercial suit, this one will be
Take,
treated
take,
as,
take.
my lord, this suit will be treated as
Take.
this suit, whether this suit will be treated as commercial suit or an ordinary suit, my lord. That
I will decide. Not to worry. If I feel I will decide, or let's see, come on that day. Okay.
This, my lord, if goes as a commercial suit, because on that point, my lord, that this is a commercial dispute.
Ashun. Even it requests, I will hear you on a limited issue of this
Commercial,
application,
commercial.
whether commercial or
I'm
not.
very grateful, very grateful.
আসুন। On the joint prayer of the parties, I'm recording it as joint prayer. To enable them to take instruction in the matter, further instruction in the matter. Comma, today's hearing stands adjourned. Paragraph, the matter shall appear under the heading for orders on December 16, 2025.
Deeply obliged.
Item number 3, chamber application for final decision.
So this is the application which had been filed by my learned friends for extension of time to file written statement, which was being argued yesterday. My lord, with regards to the time, 6th of January, they received the counterclaim. This is reply to the counterclaim.
Your Lordship, I'm being led by Mr. Ishan Shah. He's appearing online.
Yes.
So that is Mr. Torovdar. That is not Mr. Shah.
I am led by Mr. Shomobo Ghosh.
So only one thing, I would like to take inspection of the written statement which is filed in court.
এসছে যেটা ডিরেকশন দিয়েছিলাম কালকে দিদাও দেখে নি তারপর আমি দেখবো This is the written statement containing counterclaim.
This is the, my lord, this is written statement to the counterclaim filed by the defendant. I am for
Filed by the plaintiff.
This has been filed by the plaintiff.
Additional written statement.
Yes, my lord. সব আছে তো সেকেন্ড এপ্রিল হ্যাঁ তো দেখ third people.
My lord, I beg your lordship's pardon for not being there physically, my lord.
দুটো কি
In 2 volumes.
Yes.
My lord, there are 3 applications before your lordship, my lord. One is for, my lord, condemnation of the delay in filing the written statement.
Today we are on GA3.
Yes, my lord. I have an injunction application and my learned friend also has an injunction application filed on behalf of the defendant, saying that certain monies are payable to them also, my lord.
Today it is in the list. Which one?
But GA3 is being taken up by your lordship, which is the extension of time to file.
GA3 is being taken up.
Yes, my lord.
So place GA3.
Yes, my lord. Kindly allow me one minute. My lord. Kindly allow me to give your lordship the dates.
Yes. A list of dates has been handed over. Place that.
Yes, ma'am.
Yes. First, place the relevant provision after enactment of Commercial Court Act.
Yes, my lord.
What is the provision now for filing written additional written statement? What is the provision now after enactment of Commercial Court Act for filing additional
Hello.
written statement?
My lord, additional written statement has to adhere to the same, my lord, provision as to filing of the written statement in the main suit, which is within 120 days. That is the outer
Absolutely.
limit, my lord. I have
So
filed
there
within
is,
120 days.
there is the same rules, the
Same rules.
mandate of the CPC following the amended Rule 1 of Order 8.
Lordship.
Correct.
So, my
now
lord, I
in the
have
light
filed
of
within
that,
the
you
outer
please.
limit.
Yes.
I have filed within the outer limit of 120 days, my lord, but I have failed to file within the mandatory period of 30 days.
All right.
So, my lord, this application before your lordship.
Show me from your list of dates.
Yes, my lord. My lord, I'm a little handicapped today, my lord. Pardon me for making this prayer, my lord. If your lordship will allow me to come back and assist your lordship tomorrow, my lord.
Passed over for the day.
I'm extremely grateful, my lord. I apologize for not being there physically.
Grateful.
I'm for the plaintiff, my lord. Mr. Mukherjee was to come back with instructions.
Yes, my lord.
What instruction on what?
My lord, here the difficulty that my client is facing, I'm sorry. My lord, here the difficulty, my lord, will recall Section 8 application, no prayer in the master
Oh, that
summons,
thereafter.
Yes.
no prayer in the master summons or reference. Pleadings are there in the application, but I'm not on that. Your lordship wanted me to come back.
So
with the
either you
instruction.
will withdraw leave to file afresh,
Now
or I will dismiss and give you leave.
my lord, the only difficulty is, my lord, here today 120 days have passed from service of summons.
So that doesn't matter.
No, that, my
What
lord,
will happen
my lord,
because
I have instructions to withdraw it. If my lord will kindly grant me liberty to file a fresh, my lord, giving me exemption for the pendency of the application. My lord will then kindly consider my
it
application.
is a substantive application, sir.
Yes, my lord.
Either you will succeed or you will fail.
Because, my lord,
For that written statement will not, it's not
No,
a
no.
Section 14 petition.
My lord, written statement was on board. Written statement. My difficulty is Section 8 now. If my lord
I
will
will
kindly
not
have
grant
section
you any other leave.
to
I
file
will
this
sim-
application only.
Yes.
Again, my lord will kindly takes the amended provisions of Section 8 once. I'll indicate what difficulty that we are facing.
Yes.
That's the practical difficulty that we are facing. Section 8, my lord, kindly has. May I read just 8.1 only? A judicial authority before which an action is brought in a matter which is the subject matter of an arbitration agreement shall, if a
Where?
Section 8, subsection 1
Wait.
of the Arbitration
Act.
Yes.
Wait.
May I please, my lord?
Section 8. Yes, subsection
Section
1.
A judicial authority before which an action is brought in a matter which is the subject of an arbitration agreement shall, if a party to the arbitration agreement or any person claiming through or under him so applies, not later than the date of submitting his first statement on the substance of the dispute. Now, the predicament I fall, my lord, for which I am making this prayer to my lord, withdraw, but with some liberty as to at least the time period, because my lord, this point will thereafter be taken, because in sum and substance, my lord, my application is squarely under Section 8. Pleadings are all there. It is an innocuous mistake on our part, on the advocate's part, for which the litigant should not suffer. I am seeking only, if my lord observes in the order, that I am able to refile it and the date of filing is deemed to be as per Section 8. That's the only prayer I'm seeking, my lord. It's an innocuous mistake on our part to not include the prayer in the master summons. The entire pleadings are there. For whatever reason, it's a complete mistake on our part to not mention it in the master summons.
This possibly is not that simple, but the date was moved. This was pointed out.
No,
I had pointed those before the honorable court that there is no prayer for reference. My learned friend took the chance. Affidavits were filed. Final hearing. Now it is being pointed out as it was an innocuous mistake. No, it was not an innocuous mistake. So, my lord, if they're otherwise entitled to in law, they will file. But I'll have all my points open after they file.
I should.
My lord, may I
I
just
will not grant you that liberty at this stage.
my lord will then kindly allow me to place two judgments, and thereafter, my lord, then I cannot seek to withdraw. My lord, I will have to
Judgments
then,
on what?
on the point that an application per se is not required. I'll just place those judgments. I won't take, my lord, through the entirety of it. There are coordinate benches and also division bench of the Delhi High Court.
I'll my lord show the Calcutta High Court which considers those. And
It's the mandate.
My lord. No, 2014 Delhi. 2014 division bench. Whatever will kindly 2014. Well, this is a division bench of the Delhi High Court, my lord, wherein this point was considered. I'll just indicate the para numbers, my lord. Here, the point was taken only in the written statement. There was no application at all on board. It was a point taken only in the written statement. On that ground, my lord, also the Delhi High Court holds that since the arbitration clause has been referred to and a prayer in the pleading is there.
Mr. Counsel, the moment if somebody takes a point in the written statement that at the outset, he may not have taken out an application under Section 8 independently. But if he says that there is an existence of arbitration clause, therefore the parties should be referred for arbitration. And without prejudice to the above, I now deal with the plaintiff. Sufficient application.
That is done. In this case, Malad, I
Sorry,
can
no.
place the written
Kindly come
statement.
to your prayer. Kindly come to a prayer. Little here and there is permitted. But is this the prayer? Kindly come to your prayer. Kindly come to your prayer.
There is no prayer for reference, my lord.
No, not only that. It is a if I strictly construe your prayer, this is absolutely under a different statutory provision.
Lord will kindly appreciate my affidavit. If my lord is considering the master summons, my affidavit in support.
I have to know the prayer.
Lord, my humble prayer is only that my affidavit in support of the master summons.
That will not. That
which,
will not good.
and also, my lord, then secondly, my lord, in the alternative, in my written statement, categoric averment is there. It's already on record. The written statement that I have filed that has been accepted with costs imposed, paid, all of it done. Categoric averment is there. There is an arbitration clause. Kindly refer. That written statement can be treated as my application. Written statement.
You have already filed your written statement.
Yes, my lord.
With the leave.
With my lord, with this pointed out, with the arbitration. Yes, my lord. Yes, my lord. There's an order also.
What was the leave granted?
To file the written statement, my lord. I'm indicating.
Then your this application was pending.
Then it was also pending.
This pending during pendency of this application, written statement has been filed.
They were filed within 1 or 2 days of each other. This is prior.
Sir,
This
my question is very specific.
My lord.
Which one is the prior incident?
The application is the
maybe one day prior. Which is
it
the
is
prior?
It is prior.
Application is prior.
Yes.
Written statement is subsequent.
Subsequent. It is subsequent. But I will kindly consider my written statement. My averment is there categorically. Paragraph 4. Oh,
but the written statement has not yet been taken on.
It has. I'm sorry.
Oh, it is.
It's already on record with costs imposed upon me. I paid everything.
So time extended.
Yes. Yes. It's there on record, accepted on record.
Written statement.
But I'm handing over a copy.
Original
handing over a copy. Will we kindly take paragraph 4? Paragraph 4, Muller will kindly take. Loan agreement also. Before dealing with the merits, the first 2 paragraphs I've taken all are on.
Tell me where.
Paragraph 4.
That paragraph apart. 4. That apart.
That apart. The loan agreement also contains a valid and binding arbitration agreement in the form of clause 22A, which I pointed out. The arbitration clause requires all so and so. I'm not, the entire thing is there. Inasmuch as the purported suit ought to be
Arising between the disputes arising between
the parties,
the parties.
even after the loan
Even after the loan tenure to be referred to
arbitration in terms of the said clause.
said clause.
Inasmuch as the purported
Inasmuch as the purported dispute
My lord.
ought to be raised by the plaintiff in the instant suit relate to interpretation of such and such, such and such, such
the
and
loan
such. The
agreement.
subject matter of the suit is covered by arbitration clause. And the
ought to be
plaint ought to be rejected.
Next line. Next line. The purported subject matter of the present suit ought to be referred to arbitration. Categorically, it's there. Categorically, it's there. My only
Mr. Bhattacharya.
This argument has been considered by the division
Right,
bench.
now you make that argument.
Yes. Now, the point taken in the written statement cannot be equated with reference of parties to arbitration. Kindly consider the division bench judgment, recent division bench judgment of in January 2025. This exact argument was made. Kindly see, my lord, the Delhi High Court judgment was cited there. That is in paragraph 7.
এই একটা ফেরত দিয়ে দাও দুটো তুলে দিয়েছে উত্তেজিত হয়ে
Oh,
take one back উত্তেজিত হয়ে দুটো তুলে দিয়েছে
kindly see paragraph 7 first, where the defendant.
Wait.
Para 7 onwards, my lord, kindly sees. Then, my lord, para 14.
Wait. Wait, sir.
Was filed after the statement, but here. বলছে আজকে written statement এর যে পয়েন্ট আছে that should be taken as a point of jurisdiction. তখন রেফার হবে পার্টিস এখনই ডিসমিস সুট এখন ডিসমিস হয়ে যাবে পার্টি এখনই যেহেতু রিটেন স্টেটমেন্টে পয়েন্ট আছে
at the end of the trial,
at the end of the trial back
refer to arbitration.
absolutely
সেটাই তো
আমি
হবে
Register name টা দাও। Register name টা হচ্ছে 24 to Calcutta office না? Division. 21. অফিসটা হচ্ছে গীতারানী মাইতি হচ্ছে 24। হ্যাঁ গীতারানী মাইতি হচ্ছে গীতারানী। ঠিক আছে।
Consider this judgment and come back.
There are two more judgments of our High Court on the same proposition. Kindly permit Mr. Mitra to place those. আপনি বলে দিতে হবে।
No, no, I'm not allowing.
Oh, not allowing. No, not allowing. May I just give those because
In view of these judgments, in view of the judgments you are citing today, I will allow your learned friend on the other side with an accommodation to consider and come back.
আচ্ছা আর দেব না
This judgment,
And if I find that I will have to fire you on this issue, then I will fire to your senior, not to you. When senior is there, though you are sufficiently senior now by this time.
So দিয়ে দেবে কিন্তু citation
may I
Give him the
cite?
copies of the judgment so that he can.
I've been
Mr. Mitra, give the copies to him so that he can come tomorrow.
division bench. I'll also give.
And do one thing, give me all those.
Yes.
এই একটা ফাইল কিছু তৈরি করেছো? না নেই তো।
এটা হচ্ছে তোর
লিখে দাও না ওই জাজমেন্টের উপরে জাস্ট রাইট ইট ডাউন দি প্যারাগ্রাফ নাম্বার। এটা আমি পড়ে নিয়েছি, এটা মার্ক করতে হবে না।
এটা প্যারা 7 and 7 ঠিক আছে।
maybe
এটা কে দিয়েছে? এটা কে ডিফেন্ডেন্ট অ্যাপ্লিক্যান্ট? ঠিক আছে, এর মধ্যে সবকটা গুঁজে রেখে দাও। Yes.
I hand over the judgment that we'll be relying upon also. We'll be relying upon two other judgments apart from Delhi.
Perhaps
on the
your
same-
judgments are considered in these two.
At least one is definitely not. And regardless, my lord, this judgment is
You
distinguishable
come
completely.
up on that day. This is
Fine.
for your convenience. I'm requesting that.
Get his judgments also.
Yes. We'll exchange. We'll exchange.
Give him two. Give him one.
give me two.
এটা consider করা আছে।
দিল্লি আরেকটা হচ্ছে হায়দ্রাবাদ হায়দ্রাবাদ দিল্লি তোমার সিঙ্গেল বেঞ্চ উইল ওভাররাইড আর কালকাটা হাইকোর্ট ডিভিশন বেঞ্চ
I'll make my submissions on it.
ঠিক আছে
21 Calcutta
আসুন। এটা আবার কি দিল?
হ্যাঁ কোনটা এটা? হ্যাঁ এটা 7 and 70 এটা হচ্ছে 7 and
আজকে কত?
AIR 21 Calcutta page 24
এটাও নেই।
One Calcutta.
আসুন।
AIR 21 Calcutta এটা para 42 আর 50
On the prayer of Mr.
মুখোপাধ্যায়, Mr. Shaunak Mukhopadhyay.
Shaunak
Mukhopadhyay. Mukhopadhyay. my lord.
Mukhopadhyay, learned advocate appearing for the defendant applicant. The matter, the hearing stands, today's hearing stands adjourned. Full stop. Mr. Shatodip Bhattacharya, learned advocate led by Mr. Abrojit Mitro, learned senior advocate, and with Mr. Samriddho Sen, learned advocate, appear for
the plaintiff.
Paragraph. This is an application filed under Section 8 of the Arbitration and Conciliation Act 1996. Paragraph. The matter shall appear. কি heading আছে? বলো. Matter shall appear under the heading Chamber Application for Final Disposal on December 18, 2025.
Obliged.
Item number 8.
Lord, I appear for the defendants, my lord. My lord, yesterday your lordship was taking up this matter. Your lordship had indicated that I provide your lordship with a short list of dates, my lord. This is that list of dates. I'm handing up a copy to my learned. Now, this is a rather exhaustive list of dates.
Yes.
Lord, this takes into account the
What is the application for?
Lord, application for extension of time to file written statement.
Within beyond 30, but
Beyond
within 120.
Yes, my lord, filed on the 76th day. My lord, I've indicated in the list of dates, my lord. If your lordship kindly takes up,
So
my
you are
lord.
delayed by, let's say, 46 days.
Yes, my lord. My lord, the application.
Show me the written statement.
My lord, the written statement filed on the 3rd of September. So
Show me. You wish to file a written statement. You are the
Yes.
defendant.
yes, my lord, written statement was taken on record on the last
It
day.
is neither here nor
Yes, my
there.
Yes, my lord.
Show me the explanations.
Now we'll kindly take paragraph 9 of my application. In fact, my lord, my lordship kindly takes it from paragraph 9 of my application. My lord,
Paragraph
9 of my application, my lord. My lord, the suit was initially filed before the City Civil Court at Calcutta. We filed an application. The plaint was returned. And my lord, the plaintiffs, my lord, who were the appellants, filed an application, my lord, filed an appeal from that order, saying, my lord, that Order 7, Rule 10(2) was not complied with. My lord, when a plaint is returned, my lord, my learned senior friend had taken this point, my lord, when a plaint is returned by a court, the court returning the plaint ought to have endorsed the court before which the plaint is ought to be presented, the date of presentation. My lord, since that compliance was not made by the learned judge returning the plaint, my lord, an appeal was filed from that order. My lord, in that appeal, the learned, my lord, the division bench is held, which is stated in paragraph 9, my lord. Thereafter, the reasons are provided. So,
what is the finding of the division?
my lord, the division bench directed directed the plaintiffs to file the suit being compliant of the Commercial Courts Act of
So
2015.
suit was regularized.
Suit was regularized, suit filed on the 24th of December 2024.
No,
My lord,
what? 16 December. Acha, no.
yes, my lord, that is the first order of the
24th December.
my lord. The suit was filed on the 24th of December 2024 pursuant to the division bench's order, my lord. My lord, thereafter, my lord, the suit was first presented on the 6th of January 2025, my lord. That is also indicated at serial number
When
6.
the written summons, writ of summons was
My lord, issuance of writ of summons was dispensed with. My lord, the plaint was ultimately
accepted.
yes, my lord. On the 19th of June
The
20.
defendant appeared, so he accepted the written statement.
Yes, my lord.
I mean, sorry,
the
he
plaint.
accepted the plaint.
Yes,
Writ
my
of
lord. The
summons and
plaint was handed over to us on the 19th of June 2025, my lord. That is also indicated at page 20 of my application.
Page 20
of my
para
application.
para.
My lord. My lord. My lord, paragraph 11. My lord, paragraph 11. It's also at page 20, my lord. Under the cover of Mr. Mukherjee's letter, the plaint was handed us.
It is also annexed.
Yes, my lord.
Annexure page.
Page 20, my lord.
Page 20 is the annexure.
Yes, my lord. My lord, page 20 is the annexure. My pleading is at paragraph 11.
All right. Now, next is 19 July 25.
Yes.
30 days expired.
Now, 19 June 2025, the plaint was handed out. The 30 days expired on the 19th of July 2025, my lord.
18 July. Whatever. Then,
my lord, the written statement was affirmed on the 3rd of September 2025. My lord, the application for extension of time to file the written statement was also filed on that day, my lord. On the 18th of September, my lord,
when the application has been filed?
My lord, 3rd of September 2025.
Okay.
That is the 76th date. My lord, the outer limit of 120 days, my lord, expired on the 17th of October 2020.
Let me see the explanations from your supporting
Yes,
affidavit. First, show me that page 20, the letter.
Yes, my lord. Page 20, my lord. That's the letter of Mr. Mukherjee. The written statement is also annexed. It's at page 21, starts at page 20.
Yes. Take the microphone.
But the dates have been mentioned, Lord, and Lordship has taken note of the dates. Only difference was that it should have been 18th.
Let's see. Have you got a copy of the list
Yes.
of dates?
Yes.
Acha. Do you dispute that the serial number 9 of the list of dates?
No.
You don't.
19th June, I don't. I don't.
You don't. Thereafter, the explanations in the supporting affidavit.
Yes.
You tell me what do you want to say, because ultimately that is at my domain.
Yes. I just the one date which has been missed in the list of dates is the date on which the defendant here had the date that has been missed out in the list of dates is the date on which the defendant here had filed the written statement in this suit before the London City Civil Court. This suit is a transferred suit. We were proceeding before the City Civil Court. The defendant filed a written statement.
Sir. Right to file written statement is a statutory right, of course, subject to the limitation under the statute. Right? Elementary principle of natural justice. I have delivered my judgment already on this. So, admittedly, she has come up with the written statement within 76th or 77th or 80th day, let's say, whatever. Even 119, she is permitted, I allowed. And I kept the department to be to keep it open for your matter. 6:30 and then it was filed on that day. So those are very well I will take care of.
But those are I'm not talking about that he doesn't have a chance to file or she should not get a chance to file. I'm saying that she has already taken the
chance. Should we
chance.
waste any further time on this matter?
Two submissions. One is that she has already her client has already filed a written statement in the City Civil Court in this very suit. So that written statement which they already filed and on record I've disclosed that their pleading of sufficient cause is that they could not trace the written statement, and so those are the paragraphs, and so see they have to consult the same advocates who had drafted those.
All right.
That was the thing. And the one more thing is that my application for amendment of the plaint is pending.
Application
for amendment of the plaint is pending. So that if I plaint is amended, then again they will get another chance to file. Yes. So
that's the law.
I am not saying that can't. I am saying only saying that I am bringing it.
First he has to enter into the room.
That he has already entered. With a leave he has filed. Subject to result.
Unless I allow them.
Yes.
They are not yet entered.
Yes.
Mere deposition of
that doesn't create any lordship has already
neither here nor there. So if I allow, they will enter into the room. Now, if they don't like the south wall paint to be white, it should be green. And if you ultimately paint it as green, then what fixture and furniture they will post there, that's up to them. Let us stay. First, let them enter into the room.
Because of these pleadings, I will make some cost may be imposed.
Ashul. Listen to me now.
Sorry.
The instant application has been taken out. Single defendant, sole.
Yes.
Sole.
Sole plaintiff, sole defendant. Has been taken out by the defendant to the master summons. Inter alia, comma, inter alia, comma. এগুলো তো তোমরা এতদিন অভ্যস্ত হয়ে গেছো আমার ডিকটেশনে। Praying for extension of time to file written statement beyond 30 days, but beyond the mandated 30 days, but within the mandated 120 days, as mandated under the amended Order Roman 8 Rule English 1 of CPC. Poster. Paragraph. The reading of the said amended provision of CPC makes it clear that after 120 days from the service of writ of summons, it is an absolute and clear bar and the expression used in the statute is defendant shall forfeit their right to file written statement. Full stop. Therefore, if an application comes within 120th day from the date of service of writ of summons, comma, the defendant has a right to pray for an extension of time, but of course, subject to the satisfaction of the court on the basis of reasons to be shown by the defendant. First paragraph. In the instant case, the suit has been transferred from learned city civil court to the commercial division of this court. There was a challenge with regard to the transfer procedure, which has travelled up to the Honourable Division Bench. Full stop. The Honourable Division Bench, by its order dated
16th of
16th
December,
of December
2024.
December 16,
2024, my lord.
2024, ultimately has regularized
Read with 19 December order. The two orders.
the December the such and such read with the order of division bench dated
19 December
December 19,
2024.
2024, ultimately has regularized the filing of the suit. Post up. Filing of the plaint before the commercial division of this court. Post up. The plaint is now on the board of the commercial division of this court. Paragraph. The admitted fact is that by waiving the service of writ of summons, the defendant has received a copy of the plaint on June 19, 2025. Therefore, the time to file written statement under the mandate of Roman Order 8, English Rule 1 of CPC, amended Roman CPC, shall reckon from June 19, 2025. It's bold of it, June 8. Accordingly, the mandated 30 days has expired on or about July 18, 2025. Full stop. The written statement was affirmed on September 3, 2025, which, according to the defendant, is the 76th, it's a bold of it, 76th day after receiving the plaint. Pursuant to the leave granted by the coordinate bench on September 18, 2025,
yes,
the written statement was allowed to be deposited with the department. Full stop. The defendant, the department. Full stop. Paragraph. In the light of the above facts, the averments made by the defendant in its supporting affidavit, inter alia, in paragraphs 11 to 2, এইটা একটু bold করো বাবা, paragraphs থেকে 11 to 27 thereof, It appears to this court that the reasons and grounds shown therein can be accepted as sufficient and cogent. Full stop. Paragraph. Inasmuch as right to file written statement in an adversarial proceeding unless specifically excluded under a statute, is a vested right in conformity with the elementary principle of natural justice. Full stop. The amended Order 8 Rule 1 of CPC has also bestowed such right upon the defendant. Full stop. Such a valuable vested right cannot be taken away cannot be, no? May not be taken away, shall not be taken away on procedural issues as substantive justice shall not suffer for procedural lapses. Paragraph. The record reveals that admittedly the application has been taken out within the outer limit of 120 days, praying for extension of time to file written statement by the defendant. Application has been taken out by the defendant within the mandated outer limit of 120 days, praying for extension of time to file affidavit. Written statement, paragraph. In view of the foregoing reasons and discussions, the plaintiff, the defendant, shall be allowed to file its written statement, and the written statement which has already been deposited with the department shall be accepted and taken on record, and the suit registry shall be rectified accordingly, showing the written statement being on record, subject to payment of cost of rupees.
No, I'm within 20 days.
Everybody else.
Beyond 30, that's my mandate. That's the mandate on the court.
Leave it to your lord.
10,000. কি বললাম?
খুশি তুমি? লিগালের কে দেবে? তোমাকে কেন?
Suit register, registry na, suit register shall be rectified accordingly. $10,000 to be paid by the defendant in favor of West Bengal State Legal Services Authority. না এডফেড নেই, এডফেড করতে যাও না। কি বললাম? আচ্ছা, একটা ওই কালকে বলছিলেন ওখান থেকে রিপোর্ট এসছে চেক ডিসঅনার্ড হয়েছে, কস্টের চেক ডিসঅনার্ড হয়েছে, ওটা মনে করিয়ে দেবে, কস্টটাকে বাড়িয়ে দেবো আরো পরের বার। কি বললাম? Yes, Mr. Ghosh, check has been dishonored. Why? I have decided I will enhance the cost when it will come for extension. কি বললাম? West Bengal State Legal Services Authority, এটা bold করো বাবা. Positively within a period of 7 days. Positively within a period of 1 week from date. 1 week from date. Full stop. Paragraph. The learned advocate on record for the defendant shall produce a copy of the money receipt to the learned advocate on record for the plaintiff. Paragraph. On the above terms,
one sentence.
it is also made clear that in the event of default of paying the cost, the written statement shall not be accepted by the department.
One sentence may be added. There are admissions in the earlier written statement that was on record. But by filing of this written statement, that those admissions cannot be withdrawn. This may be not observed. This may be not observed because that is a case I have made out.
Against a submission.
But I have taken that point that they cannot withdraw.
You're running at the risk. I don't mind. You're making the submission absolutely against your
I am saying that by Lordship kindly
whatever you say, sir, you
kindly does not
simply
permit them to
law.
withdraw the submission by filing this, or this filing of this submission would not amount to withdrawal of that.
Counsel, you are sure I am recording, I will record this, you're making submission
I am
against
asking
you.
your Lordship to hold that, Lord, that they should not, the filing of this should not be, and that is my request, Lord.
Lord,
it will
Very well.
the law.
Very well. কোথায় দেখাবো? তো রিটেশন প্লিডিং হয় নাকি? দেখাবে এটা কোথায়?
The previous written statement is on record.
Yes.
So go by the law. What is the law?
No, that Lord, I am taking steps.
All right.
Please think that, Lord, kindly they will take this plea.
এইরকম জিচে বাস না আমি শুনি কি বলবো নেক্সট
Lord,
কি বললাম on the above terms this application it is also made clear লিখে দিয়েছো in default of payment of cost the written statement shall not be accepted and shall be returned to the defendant forthwith আর পরেরটা লেখো on the above terms this application ওই IAGA com কত 2
this is 2
of 2025 stands
kindly
allowed.
GA1 may be listed on any date according to Lordship.
What is GA1?
That is my application for amendment of the plaint.
For?
Amendment of the plaint.
It will come. Don't not mention after some time. It will come. I will allow. I will.
But there are directions for directions for affidavit. In that application, there are directions for affidavit. So that has
appear as adjourn motion.
Yes.
It will appear as adjourn motion or at chamber final disposal. So you mention afterwards. Next.
27.
এটা দিয়ে দিন এটা রেকর্ডে রেখে দাও
হ্যাঁ ঠিক আছে ওটা তাহলে দিয়ে দেবো গ্রেট ওয়ানের যে অর্ডারটা হয়েছিল অর্ডারটা ওখানে দিতে
Item number 9, GA1 is my application for
I
acceptance.
appear for the plaintiff, my lord. I am opposing 9, 10, 11. All the three application I am opposing. Two
for
one is an application, GA1 is an application by defendant number 2 for acceptance of the written statement.
Your Lordship.
GA number 2 is an application by defendant number 3 for acceptance of the written statement. And GA number 3 is an application by again by the defendant number 3 under order 7 rule 11. All misconceived applications not maintainable.
So let me take up the order 7 rule 11.
3.
If it succeeds, then we'll go. No question of filing written statement.
All questions of my opposition.
Wait.
I am for the defendant number 3. My affidavit is reply to the
এই পাশ থেকে ভরলো সাবমিট এটা লিখে দিলে ওর বিপদ yes
No, no, very well. I have two applications. One is for extension of time to file written statement.
I will hear the order 7 rule 11 first. If it succeeds, then it will go. So which one is order 7 rule 11?
IAGA number 3.
Wait.
No, no, three.
তিনটে
GA number
ম্যাটারে 9 থেকে 11 তিনটে কস্ট টাইটেল দেবেন দিয়ে একটা অর্ডার করবেন। সব অ্যাপিয়ারেন্স গুলো দিয়ে দেবেন। Learned counsel appearing for the parties jointly submit that IAGA 2 of 2025 an application filed by defendant number 3 comma inter alia comma praying for rejection of plaint. Full stop. The other applications are filed by the rest of the defendants.
Also by different number 3. I have also another application.
Other applications are filed by the defendants praying for extension of time to file their respective written statements.
2 and 3. 1 is not appearing, my lord.
Full stop. The parties also jointly submit that defendant number 1 is not represented. So the applications which are on board have been filed by the appearing defendants. Paragraph. In view of the above paragraph, the application for rejection of plaint filed by defendant number 3 is taken up first. ঠিক আছে? এবার নিচে লিখুন IAGA 2.
According to them, it's IAGA number 2, but according to me, it's IAGA number 3. Let's check. 2.
My record is
2. তাহলে 2 হবে
Master summons
আমাদের
থেকে।
তরফ থেকে।
there is no master summons blood in this application. This was blood affirmed out.
I have the master summons.
Okay, master summons.
IAGA 2. লিখুন
পরে সেপারেটলি দিয়েছিলেন।
in ray bold করে তার নিচে অর্ডার হবে শুনানির পর IAGA 2 of 2025. Yes, proceed.
Only one thing, my opposition is ready. Now, what I find,
in which your opposition is ready?
Of the application, order 7, rule 11, there was a direction to
It's
file.
your application.
My learned friend's
Oh, your application.
My learned friend's application, where there was direction to file affidavit. We have affirmed the affidavit, only the number has wrongly gone down as 3. It should be IAGA number 2.
Paragraph. Leave granted to the learned advocate on record for the plaintiff to correct the application number in the instant application by putting his signature. Do it. Paragraph. On the prayer of Mr.
Dotto.
Full name.
Meghnad
Dotto, learned advocate, appearing for the plaintiff. Time to file opposition stands extended till today. Full stop. Comma. The affidavit filed in court today is taken on record. Copy has been served.
Lordship, I have not received a copy of.
If you are a co-defendant, you are not
No,
required.
Your Lordship, to my application.
My lord has given a recent judgment that.
Lordship, to my application. He is also filing an affidavit in opposition to my application, GA1.
That will be taken up when it will be
Very well,
considered.
Lordship. He is filing it today.
When it will related, let me take up the order 7 rule 11.
Very well.
first. Yes.
I'll place the
Show me the plaint.
Yes, I'll place the facts. The only thing is I'm not
Show me the plaint, sir.
with the yes, but
Lordship, may I only interject once?
It's not part of the application. Give me a copy.
রেকর্ডে আছে কি আপনাদের কাছে? আমার কাছে এক্সট্রা কপি আছে।
Oh, you are not annexing it. You will not.
This has come from outside and we took the leave and filed
You
it.
will not even bother to carry a copy
No,
for the court.
No, I'm carrying a copy for the court. I've handed
Is
over.
this the one?
Yes.
All
I've
right.
handed over.
This is the copy for the court nowadays.
Oh, sorry, Milord. This is I mistakenly handed over my copy to my lord. That is a copy for the. Okay. This is the, with the summons.
I think I should dismiss the application. Kindly see whether this can be handed over to court.
A copy টা করে দিন।
Where we are hitting to?
এটা ক্লিপ লাগিয়ে দিয়েছে কেন? এইভাবে কেউ জজ সাহেবকে I'll come back to
Mr.
the
Junior Counsel,
This is not
we would not even dare to appear
teach করতে হবে এটা।
with such sort of preparation.
This should be I take the responsibility, Milord. Let me come back, Milord, tomorrow with Milord, this thing ready, Milord, in my end. Otherwise, Milord, I can't hand over this thing, Milord.
So pay cost for the day's cost.
But one opportunity, Milord, I should have checked also, Milord. It's missed my mind.
That you don't have
Or
time
Milord,
nowadays.
Milord Lordship kindly gives me 15-20 minutes time. I'll come back in
Do you
short
think
pass over,
this
Milord.
is
I'll
a
come.
local train running from this
Milord,
court?
I'll just tell them, I've asked them, Milord, taking steps to Milord, prepare it to hand over before the court, Milord.
Is this the way a commercial division in the original side is to be dealt with?
It's our mistake. I tender apology.
Just because the leniency that will be taken for granted. Had it been a situation that in such a situation I would have to impose 2,000 gold most cost, then everybody is ready. And this is a question of decorum. I'm the last person to take cognizance of all these things, but there must be some limit. After all, at the end of the day, I am also a human being. If this is being the way the court is being treated like this, unfortunate.
এটা ছিলে হবে না, এটা তো স্টিচটা ঠিক করে নাও।
Unfortunate.
It's not the audience side stitching.
I am extremely sorry.
But
Milord.
may I come back?
Extremely sorry. Milord. I should have checked.
Give me 1 day's time. I'll come back with everything ready on my end, Milord.
It is unfortunate. It is unfortunate. Pay cost of the day's hearing cost. All the councils have come.
Requesting, Milord, that if that may be waived, it's a mistake on our part. I also take the responsibility. I'll ensure this does not happen ever.
Annex the
at
plain
this side, Milord.
application. We are applying for Order 7, Rule 11. Very well. I'm looking it at. You don't spare a copy for the court.
I will take now. Tomorrow I will not first check myself and then will not place it for the court. Milord. Kindly allow me to come back without the cost, Milord.
Unfortunate. Ashun. It is unfortunate that a copy of the plaint has not been provided by the learned counsel, by the applicant defendant while arguing an application under Order 7, Rule 11. Since it is not annexed with the application. First. The matter shall appear under the heading Timber application for final disposal. on December 18, 2025.
Lordship, may I only pray for one indulgence. In IAGA 1, my learned friend has filed an opposition today in court.
You
So
come, you get
I am
it
only
ready?
seeking a copy, Your Lordship.
We have served the copy. The office records of my advocate on record shows the delivery of the copy. Endorse.
Very well, Lordship, but then I'll
Well, 18 would be, my lord,
meet the
early date, my lord.
Look at the way all of you are dealing a commercial code and you are appearing with preparation before the commercial code.
Lordship, my instructions are we were not served. We were not served.
Next, why client did suffer?
Since Order 7, Rule 11 is not disposed of, my lord, we can't proceed with the.
What is your application pending?
Yeah, no applications. Two.
Next. সব সমান কেউ কিছু
I
হবে
tender
না।
my apology once again. Sir. I tender my apology once again. Great.
কাজটা বাবা একটু শিখতে হয়।
কাজ ভালো হয়।
But I appear for the plaintiff. The defendant's lordship for the purpose of extension of time to file the written statement, my lord. Written statement, my lord, affirmed beyond 30 days and there is a delay of 84 days. My lord will find from page 7.
Within 120.
Yes, my lord, within 120 days, but beyond 30 days, my lord. My
Give me a
lord,
list of dates.
list of dates.
এই অর্ডারটা এরকম খোলা কেন গো? বুড়ির মতো উঠছে। অর্ডারে ফাইল নেই কোনো?
My lord, page 7, my lord, lordship will find. But at page 7.
Where are the explanations? When you have received the writ of summons?
My lord, we received the writ of summons on 2nd of April 2025. Lordship will find at page 7.
Paragraph 3.
Yes, ma'am. Paragraph 3, we have stated that on 2nd April 2025.
Your written statement has been affirmed.
Yes, my lord, it was on 25th of July 2025. Lordship will find that at paragraph 7. But then in paragraph 8 and 9, and we have tried.
Written statement affirmed on 25th July.
Yes, my lord, 25th July.
Deposited with the department.
Yes, ma'am. With the leave of the court, my lord, it was deposited with the department on 31st of July, my
lord.
On 31st of July.
Where have you pleaded?
It is not pleading. My lord, we have taken out this application, my lord, before that itself, my lord.
Master summons taken out on 30th.
And the master summons was taken out on 30th, my lord.
30th?
30th of July, my lord.
Master summons?
Yes, ma'am.
Taken out?
Yes, ma'am. Master summons. A written statement that we copied down. My lord will find
all right. Yes. Where are the explanations?
My lord, paragraph 8 and 9. But at 6 also. 6, 8 and 9.
Your application under section 10 is pending.
Yes, my lord, it is pending. It is GA2, my lord. It is appearing as item number 36 of today's list, my lord. 37 as of today's list.
Yes, what do you say?
My lord, I have three objections, my lord. First, my lord, according to them, my lord has seen at page 3, paragraph 3, they have said that the written statement, my lord, writ of summons were received on 2nd of April 2025. Now, my learned friend shows, my lord, that the leave was obtained from 31st July 2025 from this honorable court, subject to correction, my lord, that would be 121 days. When the date it was filed on 121 days. Your 31st July, my learned friend shows that there is an endorsement on the written statement that the leave has been granted to deposit it the court, my lord, the 31st July, as calculating, my lord.
Master summons is taken out?
Master summons is taken out on 30th, but he has actually filed the written statement, my lord. At that time, the
filing does not matter, sir. Unless I allow you, unless I grant the leave, filing deposited, not deposited, doesn't matter.
Then, my lord, in that case, my lord, also.
You take a situation that the written statement is not deposited with the department. Now you make your submission.
In that case also, my lord, the application for seeking extension was filed on 1st of August, which is, my lord,
which is
123 days. The application
Mr.
which
Sum,
yes,
make that
I have, my lord,
submission.
taken, my lord, the
Make
this
that
is the case
submission.
status from of this case, my lord,
All right,
GA3,
file affidavit. Make that submission.
and my lord, the second.
Make that submission. This practice to deposit the written statement will not help you if I ultimately don't allow. Even if you deposit deposit within 35th day, doesn't matter. So make that submission that the application has been taken out beyond 120.
It's filed on, it was master summons issued on 30th, filed on 1st of August, that is the appearance.
Correct. So if that is beyond 120 days matter ends, written statement will be taken off the file. Ashok. The writ of summons, comma, as pleaded in the this is an application filed by defendant number.
Defendant
many
1 and 2, my lord.
My lord,
1 and 2 has filed.
My lord, though the application has been publicly taken out by defendant 1 and 2, but the written statement which they are now trying to, my lord, that is on behalf of all the defendants. 1, 2, and 3.
Separate issue, my lord.
No, my lord.
But he is not applicant, how can you?
My lord, so far as restricted it to 1 and 2 itself.
1 and 2.
My lord, written statement also by 1 and 2, my lord. I have a copy of the written statement, my lord. Kindly have a look at page 59 of Lordship's brief. Registered address. Kindly have a look at page 59, the back sheet, my lord. Written statement.
Page 11, 1 and 2.
My lord. Yes, my
Page
lord.
11.
And also at page 59, my lord.
Why 2?
My lord, page 59 indicates the back sheet, my lord. I was showing Lordship.
This is an application filed by defendant number 1 and 2, praying for an extension of time to file written statement beyond the mandated 30 days, but within the mandated 120 days. Comma, as mandated under amended provisions of Order Roman 8, Rule English 1 of CPC. 1 CPC. The writ of summons, comma, as pleaded in paragraph 3 to the supporting affidavit, was received by the defendants, applicant defendants, bold, on April 2, 2025, data bold. The master summons has been taken out on
30th July 2020.
July 30, 2025. Poster. However, learned counsel for the plaintiffs submits that the application has been filed on August 1, 2025 which is beyond 120 days from the date of service of writ of summons. So I'm calling for a report. No
I
necessary
have also handed over a copy of the original.
paragraph. In view of the above, এই রিপোর্টটা কে দেবে এটা? মাস্টার দেবে। After consulting the suit records and suit register, learned master, learned master shall file a report, shall file a detailed report with the relevant dates. Before this court on the next day. Paragraph, the matter shall appear under the heading কিসে আছে? হ্যাঁ? কেন ফাইনালে আছে এটা? এটা তো অ্যাফিডেভিট আগে হয়েছে ডিরেকশন। তাহলে the matter shall appear under the heading new chamber application on
Items 36 and 37
on December 18, 2025. Poster.
Let items 36 and 37 also be posted on that same day. Because talks of settlement are on between the parties. Yes, Malad.
There
I
has
have
been
instructions. Today they are contemplating to sit for the
What
settlement.
are those applications?
Malad, one is my application, Malad, for stay of the suit, and the other for their application, Malad, for injunction.
Be seen when the matter will be
Yes.
called on. Chalo. I'm coming within 5 minutes. I'm coming within 5 minutes.
Okay,
For the plaintiff matters.
it's my application, Your Lordship, for the extension of time to Your Lordship. They have filed their opposition. They are out of time. We, Your
Will I
Lordship,
beg to appear on behalf of the plaintiff?
we need
Led
to
by
file our reply, Your Lordship.
Led by him, led by Mr. Banerjee. He's virtually.
Will I beg to appear for the plaintiff?
Your phone?
Let's.
Microphone.
Well, we are not for any party as to the suit. When the suit was filed, two other applications were taken out. One was for injunction and the other was for judgment upon admission. We came to know that through the order of injunction, my lord,
Order of injunction.
the one which was for attachment before judgment, they were trying to attach my property. So I'd intervened. Formal leave was given to me to intervene in the matter, and liberty was also given to file an affidavit, which I have done. So, my lord,
In the
so far-
injunction application.
the injunction. So attachment before judgment.
This is
As far as this application is concerned, I have nothing to say.
I was praying for extension of time to file reply, Your Lordship. It's ready. Client is not
No,
well, so
question
he could
of
not.
reply. Yes, you give it now.
It's not affirmed
May I
because he's
just-
not well
No, you're,
So he has-
appearing for?
for the defendant, Your Lordship. Respondent,
Sole defendant.
sole defendant, Your Lordship.
So I can hear out your application for extension. Where is the problem? They have filed opposition.
Opposition.
I will only satisfy myself whether sufficient cause has been shown
Lordship.
first.
So we need
If it
to.
is between 30 to 120, that's all.
We need
Yes.
to certain documents, Your Lordship. In the opposition, they have said so. Some allegations are there. That
Let me
the
see the application. Then
Lordship.
I will. When the writ of summons was served.
As per me, Your Lordship, the copy was served upon the different person's office. Office bearer has received it, and we were given a copy on 9th of April, Your Lordship.
No, you are a company.
Lordship, my office was closed.
Have you obtained any report from the
I have.
office of the sheriff?
They have.
Lordship, it's in my affidavit in opposition, page 13.
Page?
13 of my affidavit in opposition.
No.
Affidavit in opposition to GA3.
নেই এখানে নেই
Not my opposition, page 1-3. I'm so sorry. Page 1-3. Not the date of service by the belief was on 2nd of April. They are claiming, the defendant is claiming that the copy was served through post on 9th of April. Your Lordship will kindly find from page 1-3 itself that the summons was dispatched by
it is
registered
wait
post. My
it is affidavit of Nodiyanandan Nandi.
Nodiyanandan. My lord.
Page 13 is the report.
Page 1-3.
Let's see the report.
My lord will kindly find in the first table at the fourth. My lord,
Wait.
My lord.
Yes.
Lordship,
What do
the
you say,
name
sir?
Pratima Roy is not my employee, Your Lordship.
Not your employee.
No, because my office is closed. Company is in words of closure, Your Lordship. That is why the properties are being sold and other things which they are trying to attach. So this Pratima Roy is an employee of another office which is just beside me. Since my office is close, Your Lordship, we don't go even. That is what we have written a letter that I want to bring on record on.
All right, all right.
So the Pratima Rai works with the another company which is just beside my office. They received it. They kept it with them. When we went there, they have handed over, Your Lordship. And the tracking report, which is they are saying it's not received, Your Lordship. So
Not available.
not available. So that is what we want to bring on record, Your Lordship.
No, that's all right. That's the difficulty.
So that is what the reply we want to find.
May I just indicate before your lordship grants them one further opportunity to file the reply. Lord, the reply was directed to be filed, my lord, by an order of 16th of July 2025. Thereafter, my lord, once extended on 28th of October. Now, my lord, today they are finally coming up with a reply without serving any copy upon us.
How
Lord,
do you
I'll leave it to
satisfy?
your lordship.
You satisfy me on page 13 of your opposition?
Your lordship will kindly, my lord, say that the registered office, the service is by the belief upon the registered office. Lord,
Where do I
subject to
get that?
correction, the registered office, your lordship will kindly find, Lord, which is there in the cost title. The address will match.
Does not matter, sir.
May I try
You
and
show
indicate,
me
Lord?
from page 13. You satisfy me on page 13 about the service.
Lord, this was dispatched, subject to correction, Lord, this was dispatched, Lord, through due course. My Lord, the plaint was, the summons was served through the belief, and Lord, no other address was provided. So, my Lord, perhaps, my Lord, subject to correction, Lord, if it is done in due course, my Lord, perhaps the presumption will automatically first arise that, Lord,
Judgment of order 29.
Carrying that, my
and my Lord, yes, we have also,
carrying the judgment which my
You are carrying the judgment.
yes, my Lord, we have, my Lord, we have been
my
fortunate
senior,
enough,
it's
my Lord,
helping
to
us on this
find it.
aspect. I'm
So
carrying.
come out of the rigor of my judgment.
Subject to what my senior says, the judgment helps us, my lords.
Helps us. Helps you. Why?
Lordship, because Lordship has held in the judgment that Lordship has held that the or in order 29 would also mean that if the right
mutually exclusive,
Lordship, and it also would mean that if the
one mode is sufficient,
Lordship, and if the post has been left in the office, if the post has
how do I know that?
Lordship, over here.
Kindly see, that's why I am asking from page 13, you satisfy me.
Lordship,
I'm keeping in my mind of my judgment, I have asked this question.
Lordship will just kindly visualize a writ of summons when it is filed. The writ of summons is we lodge the writ of summons with the sheriff office with the cost title page, and the sheriff attempts to do the service at the exact address provided in the cost title. Now, Lordship, this is what we are given when we seek for a report from the deputy.
Mr. Counsel, these are nothing. You show me and satisfy me on your page 13 that it has been delivered.
Lordship, page 13, the first column that my learned senior friend was showing you.
You submit, tell me.
Lordship, it says that one
Yes,
duplicate copy of the writ of summons along with plaint, that is the material to be served. Date of service is 2nd of April, served by Rajesh Kumar Mondal, the second officer. Lordship, the address of the defendant is not mentioned here.
Sir, what then upon whom it has been served?
Lordship, Prathoma Roy Dasgupta, staff of the defendant company for and on behalf of the defendant.
So do you come within the purview of my judgment, the law laid down by the court? Have you read that judgment?
Yes,
Tell me, how do you come within the purview?
Just gives me a moment, Lordship.
May I try to satisfy here?
Lordship,
Yes.
let my learned senior friend, he's there.
If your lordship kindly takes up, Lord,
Hand
those
over the
copies
copy of
handed
the-
over. Lord, may a
I
copy be
don't
handed
care.
over?
You just first you tell me, then.
Lord, may I read out from paragraph, subject to your lordship's kind permission, from paragraph 23. Perhaps that is, Lord, the decision, the ratio starts, Lord, from paragraph 19. And Lord, perhaps, Lord, paragraph 23 will be
আমার একটু
relevant.
আজ ফাইলটা রোজ চাই ভাই।
Lord, if I may read out, Lord, paragraph 23 onwards, paragraph 23 to 28 is what I intend to place with your lordship. But if I may.
Yes, yes.
Paragraph 23, if I may read out. In the facts of the instant case, the case of the defendant is that the writ of summons has been served at the registered office of the company, but the service report does not disclose that it has been served upon any of the designated persons within the meaning of Rule 2A to Order 29 of CPC. It is not denied by the defendant that the writ of summons has not been served at the registered office of the company. As such, on reading of the provisions as provided under both Subrule A and B to Rule 2 of Order 29 of CPC on their interpretation, the court is of the considered view that once the writ of summons has been served at the registered office of the defendant company by the office of the deputy sheriff, as would be evident from the deputy sheriff's report and the postal track report appended thereto, showing delivery of postal article at the defendant's registered office on November 14, 2024. It is sufficient and lawful service of writ of summons on the defendant.
That's what I'm asking you. Satisfy me from page 13.
That building has so many.
13, not page
13 of
13,
your
not,
opposition.
not
Satisfy
page
me.
13. But page 13 shows, my lord, as my learned colleague there also pointed out, my lord, the summons is lodged with the office of the sheriff. Now, my lord, it is only the cause title page. The cause title page will be, the address will be found from the cause title of the plaintiff itself. Now, may I just indicate this? Now, my lord, the address is not indicated here. What is not troubling your lordship is perhaps the name of the person and how he was determined to be a staff. Now, my humble submission is,
So,
my humble submission is,
on relying on page 13, which column you're relying for effective
Lord,
service?
I am first, I am relying first, Lord, your lordship will kindly, Lord, look at all the columns. Lord, one is first, the first column is, Lord, one duplicate copy of the plaint of the writ of summons along with a copy of the plaint. This is the, Lord, material which was served. Then, Lord, the
Served
date of
upon whom?
service.
Served
Thereafter,
upon whom? Come on, served
yes.
upon whom?
Now service on the in the fourth column. Lord, such and such name and is, my Lord, in the opinion or in the
So
finding
this
of
is
the
a good
person
service
serving.
according to you.
Lord, subject to correction, Lord, this was, if your lordship kindly allows me to place order 29 once,
Yes,
Lord.
I have read in detail.
Your lordship
You
has not
tell
in
me.
detail, Lord, dealt with this, Lord, in that judgment. Lord,
Yes.
if your lordship kindly says, Lord, the service upon the registered office, Lord, does not require, Lord, if it is read in disjunctively with, Lord, clause A.
That's
Then, Lord,
precisely, but you satisfy me that Prathama Rai.
Lord, this is only a person who is receiving.
That's
Lord,
right. Who has
Lord,
to
the
receive
requirement.
who has to receive under order 29?
Under order 29 clause B, but perhaps it is living, if the bailiff leaves it with any person in the registered office, Lord, that is perhaps not
I
sufficient.
absolutely agree with you, but show me that it has been served at the registered office.
Lord, registered office, the address of the registered office is not appearing from page 13, but page 13 has to be, my lord, under due, my lord.
Please satisfy me on your page 13 that it is served at the registered office. I'm absolutely with you. I will be absolutely with you.
The
So,
registered office is not appearing on this page.
then why,
I'll have to admit.
how will
Now,
you cover?
I
Why
am
order
I am
20?
trying to draw a connection, but perhaps the lordship may also, my lord, call for a report which will, my lord, clarify the situation that where on which address this, my lord, service was affected by the delay. Lord, perhaps a report will also
Sir,
clarify.
counsel, kindly come to the second table.
Yes.
What does it say? E-tracking report is not available.
Yes, that is not available. Your lordship will also kindly.
Does it mean receipt at the registered office?
No, it doesn't.
What
But
will
your
you
lordship will
argue?
also kindly.
Then what will you argue, sir, on this?
Lord, on the second column, Lord, I am not placing the second column yet because that is by registered post. That is the other mode of service contemplated under Order 29, subject to correction. And Lord, your lordship will also kindly see the date is of 8th of April. The 8th of April is the date when it was on which it was registered. And in their application, Lord, they admit that the service was affected by registered post on 9th. That is their admission in the application. So this is the mode by registered
The
registered
application
post.
was received by this Pratima Rai in the another office where it's not my office.
This is nothing. This is not. This is
He's
a
saying
submission
that
from the bar.
registered office. Show me. That admission, show me.
Lord, if your lordship kindly takes up their application.
Yes. Show me.
Their application, Lord, for Lord in the.
Yes, sir, I'm at their application. Show me.
Lord, if your lordship kindly takes up page 2. I'm sorry, paragraph 2 at page 3 of their application. Lord, they say, my lord, the writ of summons. Paragraph 2, my lord, if I may place.
আজকে কি আমার কেউ আসেনি রেগুলার? হ্যাঁ, কে? ও আসেনি, ঠিক আছে। Show, read it.
Lord, what they say in their application, Lord, the writ of summons along with a copy of the plaint was served upon one of the employee of the neighbor office of your petitioner, defendant, on or about 9th of April. Since the company office was closed, in the said writ of summons, the petitioner was directed to file written statement within 30 days from the date of service of writ of summons, that is on 9th of April.
So they
Now, my
admit
lord,
the service. This is
they
a,
admit service, but not on the registered office.
they admit
Now,
on
they admit, they say what they say is that the service was effected on on a neighbor office. Now, your lordship will
that
kindly
is a
find
good
the.
service. That is a good service.
I'm not
according
saying.
to
I'm
you.
not. That is not my humble submission.
Then
But
why
my
you are
humble
using
submission.
paragraph, sir?
My humble submission is, my lord, just to show, my lord, that they have received service. They say
We have not
uh,
received.
the what they say on oath, what they state on oath is that it was served on a neighbor office, the address of which is also not provided.
So
But
that
this
is
is
good
only my
service.
humble.
That is good service.
Not my humble submission is not the registered office. The service has to be effected on the registered office, not by through the plane. The address is provided, is lost before the office of the sheriff or the
I'm
learned sheriff.
absolutely with you. You show me from your page 13. It is served at the registered office. Show me page 13.
Second officer has to.
Then immediately I will discard their claim in view of my judgment. Show me.
But may I not humbly then beseech your lordship, my lord, to call for a report, my lord, that will clarify the entire position.
Then
The
why
address, your lordship, what
why
is
you
troubling your lordship is
why
only.
you have wasted the time unnecessarily for half an hour?
I just attempted to show, my lord, that the
What
under, my
attempt?
lord,
You are welcome to you make your attempt. Tell me that
but
this is a service.
I only attempted to, my lord, place before lordship subject to correction, my lord, kindly, but do not
Huh?
take me amiss, my lord. Kindly do not take me amiss. I only tried to show before lordship, my
No,
lord, that
absolutely,
if
you
it
are
is not.
free to try, but your try must be a bona fide try. Should be a bona fide try.
Perhaps, my lord, subject to correction, subject to acceptance by your lordship, my lord. The presumption has to, my lord, go in.
This according to you, good service. Page 13 of your affidavit in opposition. I will record that. Don't worry. I will record your submission.
But then, my lord, if I leave it to your lordship, my lord, kindly, I beseech your lordship that kindly calls for a report, my lord, that will entirely clarify the position, that whether the address on which this beliefs service was effected is the registered office.
भाई এটা নিলাম তোমার এক কপি।
This is an application filed by the defendant praying for extension of time to file written statement. শোনো বাবা, কোথাও যদি কিছু বুঝতে না পারো আমার সঙ্গে সঙ্গে 15 বার থামাবে, 17 বার জিজ্ঞেস করবে, কিন্তু ওরম ভাবে বেরিয়ে যাবে না। হ্যাঁ, দেখো কি বললাম। File written statement beyond the mandated 30 days, but within the mandated 120 days, comma, as mandated under the amended Order 8 Rule 1, Order 8 ta Roman, Rule 1 ta English of CPC. Under the amended provision of Order 8 Rule 1 of CPC. The plaintiff through its paragraph, the plaintiff through its affidavit in opposition has relied upon a report of the office of the deputy sheriff dated April 20, 2025. Annexure A, comma the Annexure A at page 13 to the affidavit in opposition. Full stop. Paragraph. On perusal of the report, it does not appear to this court with regard to the detail of service came to have been served through speed post with AD. Paragraph. Accordingly, The office of the deputy sheriff shall file a report on the next day, along with the necessary postal track report, along with the relevant postal track report, and with the relevant certificate to be obtained by it from the office of the Postmaster General, jurisdictional Postmaster General. Poster. You have already deposited the written statement.
It is filed. It is filed with the subject to allowing this application.
Full stop. When? What is the day according to you?
It is also annexed with the lordship, with our application.
Sir, I'm asking that on which day you have filed? Before 120th day?
Yes, before wanted. On
Which
the last
day?
day, on lordship. 9th of 5th of August, it was affirmed. Perhaps your lordship on I have to check it. Lordship.
The full stop. Learned Counsel, Mr. Rajesh Upadhyay, appearing for the defendant, submits that the written statement was affirmed on
5th of August.
August 5, 2025, and pursuant to the leave granted by the coordinate bench, it was then submitted before the department. Paragraph. The office of the learned master is no. According to you, when 120th day expires?
On 9th of August, your lordship.
According to him, Oshangi, ha, Baba. The mandated 120th day from the date of service of writ of summons has expired on August 9, 2025. Paragraph. In view of the above, the office of the learned master shall also file a report with regard to the date of submission of the written statement and shall produce the original written statement on the next day. Paragraph. As prayed for, time to file affidavit in reply by the defendant
Week's time, your lordship.
stands extended till
Next witness.
December 17, 2025. Paragraph. The matter shall appear under the heading. Paragraph. Chamber application for final disposal on January 8, 2025. 26. Thank you.
And one more submission, if your lordship kindly permits me. There are two other applications which are there in the list. Your lordship kindly.
Next.
In this matter, my lord, I appear for the petitioner, decree holder.
Okay, for examination of judgment data, my lord.
Yes.
Judgment data is here, my lord.
What is this application?
But I am, my lord, the landlord of the
What
property.
is this application?
But this is an execution of an order passed by, my lord, your lordship's predecessor bench, directing the tenant, defendant herein, my lord, to pay the arrears of rent as well as the monthly rent. My lord, the defendant has failed to make any payment. In fact, my lord, the affidavit of assets, if your lordship sees, shows that in the bank account only 1,300 rupees is there. That apart, my lord, the defendant discloses one property which is valued at, my lord, about 1.15 lakh rupees. But the monthly rent of the premises is 1,09,000 admittedly. 1,09,000. The amount outstanding as on date is about 68,82,000 as per, my lord, my pleading in the execution petition. But 5 years, no rent has been paid. And my lord, outstanding amount, as I said, my lord, is about 68,82,000 and continuing to increase because every month rent is becoming due and payable.
Yes, sir.
So I have an
Audit manager is leading me, my lord, in this matter.
the valuation, how he got the valuation.
Tell me.
But that property valuation, I object.
That is a disclosed, my lord, the detailed
80 lakhs by next week.
No, Lordship, we are not, we have given a proposal, we are not in a position to bid. We do not have that
Then
financial.
be inside.
Lordship is there to face the examination, Your Lordship, as per the
Doesn't
last.
matter. First, I want to see the bona fide. 30 lakhs by next day.
Lordship, bona fide, Your Lordship, we have given a proposal itself in our affidavit of assets.
No proposal, no proposal. That is between you.
We'll pay at a time, Your Lordship.
You have to deposit 30 lakhs with the registrar next week.
Lordship, let him examine my witness. He can find out anything.
It will be done. It will be done. If necessary, it will be done inside.
Sir, my lord, I'm led by Mr. Thakkar.
It will be done. If necessary, it will be done by way of a commission inside.
Lordship, once it is held that he doesn't have any property from which he can pay the money. Lordship, then
So
Your Lordship,
he will go merrily.
no. Then Your Lordship, I believe that Your Lordship, the consequences will follow.
Tell me, deposit 30 lakhs with the registrar next week.
Lordship, we are in a position to deposit.
So let him be inside. I'm issuing an arrest warrant of arrest immediately.
Your Lordship, I will have to argue on if a person does not have the funds to pay, if he is otherwise insolvent, then Your Lordship, imprisonment is not an option.
Show
Your
me the
Lordship.
declaration of insolvency.
There is no insolvency declaration, but there are no assets in his name.
That
Apart-
is, you think he is insolvent.
Let him sell the property.
According to law. Either you pay by next week or you be inside. I mean, not you. Your
No,
client.
I understand you.
Come on, tell me.
Movable property, Your Lordship, let
He's still occupying the premises.
Yes. No, he's running a business
Oh,
there
you are occupying the premises.
and running business.
Your Lordship, running
Flourishing business.
that for that there is an eviction suit. They have filed a suit. That Your Lordship.
You're running the business.
Yes, Your Lordship, running the business.
So deposit 30 lakhs with the registrar, not to them, not to the
Lordship,
plaintiff.
the income is not more than 2,05,000 and the expenses are almost more than 1 lakh for paying staff salary and all. That we are maintaining the books of accounts. We have all the documents on record to show the
This is
expense.
only the areas in rent, my lord. And that too at the normal rate.
So I'm passing my order.
Your Lordship will not send him, let him face examination. Otherwise, and we have also
What
got a
he will
property.
First, I
Lordship-
must test his bona fide. The decree has not been challenged, it is crystallized.
No, it has been challenged. We have lost.
Challenged and dismissed.
Challenged, and then what is the result of the
Lost.
challenge?
Lost. We have lost.
Cost also not paid.
So
But the-
better pay 30 lakhs with the deposit 30 lakhs with the registrar next week.
Lordship, next week is a too shorter time. Kindly give us some more time. Your Lordship.
When the decree was passed.
2025.
1 year.
We have challenged. In the meantime, the appeal was
When the
pending.
challenge failed.
April 2025. May 20th May 2025 appeal dismissed with costs. And the,
Cost paid.
no.
Cost has not been paid.
Then my client to prison, it will be an automatic eviction.
All
without,
right.
Without getting a decree, Your Lordship.
Ashu.
We have a property, Your Lordship. Let them take possession of the property and sell it off. Your
No,
Lordship.
no, what property?
And just
What property?
property, Your Lordship will see my affidavit of assets.
Yes, yes.
अरे आया ही नहीं है.
Your Lordship, let him first face the examination. Otherwise, Your
Yes,
Lordship,
yes, he will face.
request Your
He
Lordship
will
not.
face if necessary, sir. If necessary, from inside, he will face. No problem.
Your Lordship, that is a consequence, Your Lordship. Once he faces examination, if it is found that he has no other property,
And if it is found that nothing is there, he will merrily enjoy the property without
Lordship,
paying a farthing.
the
Yes.
Lordship
All
knows
right.
that Jolly Roger judgment, Your Lordship, if someone is
Yes, yes.
doesn't
Every judgment I will
pay,
see. All the
Lordship, allow
judgment I will see.
is that position of law.
You
Your
know, the
Lordship,
next day,
one
bring one
tell-
judgment that despite the decree being crystallized, it is not executable.
No, I am not saying that it is. That is not my case. It is definitely executable.
Ashuna.
But give me a chance to
Yes, yes, I'm giving you a chance. 1 week
No, Lordship
to
will grant me
deposit.
some,
To
he
deposit.
likes,
আসুন কোথায় গেল?
grant me some more time. Your Lordship, let us, we also can let us.
IAGA কম 1 না এটা হচ্ছে IAGA না ইসি এটা only ইসি
Yes.
লিখুন this is an Mr. Thakkar Mr. and both of you listen to me while recording the fact. This is an application for execution of a decree dated
24th January 2025.
January 24, 2025. Post up. The decree was for eviction.
Decree was for payment of arrears of rent and occupation charges ongoing.
Final
Decree was not for eviction.
No, no.
The decree was for payment of occupational charges
and arrears in rent.
And the arrears on that score. The total amount crystallized under the decree is for a sum of rupees
68,82,750.
Vote করে দিও 68,82,750
with further accruals of 1 lakh per month on occupancy charges.
Full stop. In addition, the judgment debtor has to pay
1 lakh
a sum of rupees 1 lakh per month.
9,250. I'm sorry.
1 lakh 9,250 per month
On and from March 2025.
as occupation charges. Paragraph. The judgment debtor had preferred an appeal from the decree. The Honorable Division Bench, by its order dated
May 20th, 2025.
May 2020
25.
has dismissed the appeal with a cost of rupees
10,000.
10,000. Paragraph. Thus, the decree has been crystallized against the judgment debtor. Oblique respondent herein. Paragraph. Affidavit of asset filed today.
No, it was filed earlier, Your Lordship, on 23rd June.
And paragraph. An affidavit of asset filed by the judgment debtor oblique respondent is already on record, which inter alia discloses few bank accounts where into
para 5.
Para 5, bottom of page 3.
Which কি বললেন?
Having a total balance of 1,300.
1,300. Discloses the bank accounts with the balance lying thereat. In paragraph 5 of the said affidavit. The particulars shows in one bank account 500 and odd, comma, in the rest two 400 and odd and 300 and odd sum is lying. And the fourth one with Axis Bank, it is only 0.21, rupees 0.21. This clearly shows
Paragraph 6 have disclosed an immovable property along with the deed.
financial health of the judgment debtor.
My lord, we have disclosed an immovable property as well in paragraph 6.
Yes.
Paragraph. Paragraph 6 to the said affidavit discloses an immovable property for about 2 katas, 8 chitaks of land.
Which,
Your
which
Lordship, Your Lordship,
At
character 8, we have also disclosed the name of a debtor from whom we are
It's Khelarampur.
tilted.
Mouja Rajarampur.
The total value bought at 1,15,000.
Ki?
The consideration in the deed which he has disclosed is 1,15,000.
That was way back.
It is
Deed is at page situated at, tell you, Lordship.
Rajarampur. Situated at
Schedule, Your Lordship will find
Mouja Rajarampur,
7.
Rajarampur,
Gram Panchayat, Sirakol, Gram Panchayat,
24 Parganas.
comma, Silakol,
Sirakol, SIRA,
SIRA,
KOL, Gram Panchayat,
KO,
KOL,
KOL, Sirakol, Gram Panchayat,
South 24 Parganas.
comma, 24 Parganas South. Paragraph 8 of the affidavit mentions about an actionable claim for a sum of rupees 8 lakhs.
नहीं लिख रहा है इतना डिटेल.
In view of the above, the judgment debtor is granted one opportunity to pay off the decretal dues. First up, paragraph. At the first instance, the judgment debtor shall deposit a sum of rupees 30 lakhs with the landed register original site on or before আজকে কত
It's 26th, my lord.
December 9, 2025. Paragraph.
Kindly give us some more time.
In the event such deposit is met, comma, the registrar original site shall invest the same in a interest-bearing fixed deposit amount with any nationalized bank of his choice and shall file a report on the next day before this court. Paragraph. The affidavit of asset further discloses and it is submitted on behalf of the plaintiff decree holder that the judgment debtor is carrying out his business from the
suit property
premises of the plaintiff as described in the cause title of the application, where the detail of respondent has been described. Full stop.
This is the photographs at pages 7 to 21.
The business is running, but no payment is coming. To the till of the decree holder. In view of the above, both of you. No. The gentleman behind you, yes. You also. I will appoint receiver. Both of you.
Receiver for
In
taking
view of who is senior? Decide and tell me.
I might be deceived.
You might be, will not do. Discuss among between yourself.
Your Lordship appoints a receiver over the property and take possession, it will amount to automatic eviction. For that final decree is pending, there. That is the final prayer in the.
Who is senior? Very well, I will appoint you, Mr. Banerjee.
No, Lordship will not. No, Lordship will not give me that trouble.
Abhishek.
What's your name? Who is senior? Huh?
Abhishek Chakraborty.
In view of the কি বলেছি?
Will not appoint someone for taking possession.
Mr. Abhishek Chakraborty, learned advocate, give your phone number. Bracket such and such. And Mr.
Uttiyo Malik.
Uttiyo?
Uttiyo Malik. UTTIYO Uttiyo Malik.
Malik. Give your phone number. Learned advocate, comma. Members of the bar, comma, are appointed joint receivers. To go and visit the premises wherefrom the business is being carried out by the judgment debtor and to make a detailed inventory of the same. Full stop. Full stop. The inventory shall be made upon prior notice of 2 days, 2 working days, upon the defendant to be issued by the learned joint receivers. Paragraph. The representative of the decree holder and the learned advocate on record shall accompany the joint receivers at the time of causing the inventory at the premises. Full stop. The judgment debtor shall arrange the necessary conveyance for the joint receivers, including their return to their respective destinations.
To judgment debtor. Decree holder, Your Lordship, decree holder.
Sorry, কি বলেছি? Thank you. You're right. The decree holder. Right. You're right. Because it will be ultimately added to you, that is later. কি বললাম? Conveyance. Destinations. Full stop. The joint receivers shall draw up a minute in presence of the representative of the judgment decree holder and the learned advocate on record, and also in presence of the judgment debtor. Full stop. Paragraph. The joint receivers shall file a report before this court on the next day. Paragraph. The joint receivers shall be paid an initial remuneration of 25,000 each by the decree holder at the first instance. Full stop. Such payment of remuneration by the decree holder shall be considered at the time of final disposal of this application. Full stop. Paragraph. The judgment debtor shall cooperate and render all assistance to the learned joint receivers to cause the necessary inventory at the premises. Paragraph. In the event of any resistance is created, the joint receivers shall be at liberty to ask for police assistance of the local police station by serving a copy of today's order upon them. And in that case, all necessary assistance, police assistance, shall be provided to them to carry out the direction of this court. Paragraph. The matter shall appear under the heading কিসে আছে?
After that 2 weeks, the time which your lordship has granted for that 30 lakh payment, which is 9,
after that,
to be mentioned, my lord, on the next day, we'll report compliance, because we'll have to report compliance, my lord, whether.
It is appearing under chamber application for final disposal.
Right.
The Banerjee has
Shall
his way,
appear.
will not appear.
No, but affidavit filed. Opposition?
Yes.
Opposition filed.
Not filed.
Opposition? No. Affidavit
Not filed. They appear under the heading.
They never sought direction.
New chamber application.
Grateful.
Your Lordship, now I am seeking directions to file it.
Yes, afterwards.
After. Let it appear once.
By the next date I will file. Your Lordship will give the direction. By next date I will.
New chamber application on 2 weeks কবে শেষ হচ্ছে আজকে কত?
Today is 26th. Your Lord.
On December 16, 2025. Anything I have missed out?
No, Your Lordship has given them all the protection.
All.
Yes. For at least today, all the protection, and we will cooperate with the receiver. Your Lordship, there will be no resistance.
Absolutely. Deposit the amount, then I will grant you interest. Installment.
I will talk to you.
Ask your client to deposit the money with the registrar. Then I will consider the installment. Not to worry.
Grateful.
Not to worry.
Grateful. Extremely grateful. I will talk.
Live and let live. Ask your client to believe in that. He shall also carry on his business peacefully, and the payment shall also be made to the plaintiff. Right?
I will.
Advise your client. I will grant you installments. Not to worry.
Grateful, Your Lordship.
There, if necessary, I will simply jump on the judgment decree holder.
Yes, ma'am.
But
Mr. Banerjee has to use his good offices rather than filing multiple appeals, maintainability applications, Order 7, Rule 11. Everything has been exhausted. Everything exhausted.
Mr. Thakkar.
So I have to defend my client.
So long it benefits Mr. Banerjee.
We cannot
and all
say.
of you,
We cannot
all of you,
We should not
beneficial for the profession. I don't mind. Carry on.
Not
But
about-
the purport and content of the decree should be carried out in its true effect and spirit.
Yes, that is your
Other than that, whatever you want to do, carry on. No issues.
Paid by me is to only for protection of the interests of my client. Nothing else, Your Lordship. Nothing else.
On the next day,
receivers should file.
Opportunity for filing affidavit by the judgment debtor shall be considered.
Great.
Do that. Deposit 30 lakhs. I tell you, I will then give you installments so that you can also survive.
I will definitely talk to the
Not to
client.
worry. Not to worry. Do that.
I will. Great.
Lord, my execution application, my lord. My lord, yesterday, my lord, judgment debtor number 4 had surrendered himself and the affidavit of asset had been filed. My lord, there had been 3 affidavits of asset, my lord, which had been filed by the judgment debtor number 4, judgment debtor number 6, and judgment debtor number 7. My lord, the rest of the affidavits of asset had not been forthcoming, my lord, as of now. My lord, the decree, my lord, was at that given point of time, the claim made in the suit was $4 lakh 20 suit for recovery of money. Goods sold and delivered.
To
Goods sold and delivered.
how many defendants?
My lord, there are 7 defendants.
How
8 defendants.
They are related to each other?
My lord, the relation was they have all been acting in concert. There were goods exported and the goods have been delivered.
Decree was jointly and severally.
Jointly and severally. Jointly and severally?
Show me.
Yes, ma'am.
Who is appearing for whom?
Murder. I am appearing for judgment debtor number 1, 2, and 3. Who are the defendant number 1, 2, and 3? Well, I took an application for transfer of this execution proceeding against me to Bangladesh because I'm a foreign national. All 3 of them are foreign nationals. That application is there. If pleadings are the directions for filing affidavits, we have received their opposition. I have also prepared my affidavit in reply, but I could not serve a copy upon them. Well, I'm serving him right here and now, and I'm filing my affidavit.
1, 2, and
3. There are 3 defendants who are outside jurisdiction of this court.
What about the others?
My lord, I'm appearing for number 4. I appear on. My lord, I'm appearing for judgment debtor number 6 and 7. My lord.
How you are related with each other?
I am not related to any of them.
My lord, if I may indicate, my lord, I am the transporter and the custom clearing agent. It's a suit for recovery of money.
Let me see the decree.
Sold and delivered.
Yes, my lord.
In decree, we have been held jointly and severally liable to pay
the decree, my lord, the drawn up decree.
So how will you pay off your debt? What is the total amount?
My lord, the total amount as on date would come up to around 9 crore odd.
9 crore odd.
9 crores odd. That has been quantified, my lord.
Execution application copy
at paragraph 12 of my execution, 12 and 13, my lord. The exact sum of money would be 9 crore 81 lakh 84,205.
So how will you pay?
But if my application succeeds, Miller, for transfer of the execution,
it will be taken care of. But tell me, how will you pay first?
I am not within the.
Take the microphone.
But I am not within the jurisdiction of this court. I am not within the jurisdiction of this court. I am a Bangladeshi. The case proceeds that I'll just indicate.
How were you involved in this business?
That they say that they were to supply me goods and I were to pay. These 3 were to pay them for the value of the goods. According to them, with the defendant number 4 had managed to synchronize the entire mode of transfer, and other defendants till defendant number 8 were involved through defendant number 4, and that's how the suit was framed. Now, I, being the Bangladesh parties, we have filed 3 prior suits regarding the sales and transactions in Bangladesh, taking the point that the goods never reached me. These goods never reached my destination, and that's why I was not entitled to make any payment. The discrepancy that was there in the bill of lading. There were discrepancy, and that is why the bank did not release the payment, and that was their cause of action. Now, on the basis of that, with pleadings of fraud, they filed the suit. And decree has been passed ultimately, but only 2 defendants actually contested the decree, although our clients filed written statement, but we did not lead any evidence. At that point of time, my client could not contact with the lawyer who was representing.
Neither here
not there. 2 defendants contested the suit by reducing evidence, 677. They thereafter took that decree to appeal. Appeal has been dismissed. This is the status. My client, as on this date, have not filed any appeal or challenged the decree. We are in execution. I took out the application for transfer of the decree. That is the status.
That's right. The moment you have applied for transfer, you are admitting the decree.
I'm only saying that there are 3 prior suits, and my defense is that
here not there.
That has not been. That is
those cannot be taken as defense in your execution proceedings.
That is them.
So who had preferred appeal?
That was dismissed, my lord. Subsequently, we have preferred a special leave petition, which is pending, my lord. My lord, I am the transporter who has simply transported the goods after collecting it from the plaintiff.
Along with you, who had preferred appeal?
My lord, me and the custom clearing agent, who is judgment data number 6 and judgment data number 7.
You are appearing for both of them.
My lord, both of them. My lord.
Yes, sir. How are you?
Judgment letter number 4.
Take the microphone.
My involvement with respect to the suit proceeding was that my wife, the allegation has been that I had induced the plaintiff to take the goods in question from my wife, who was the business proprietor. That was my involvement in the suit proceeding. That's the allegation.
So how will you pay now the decree has come?
Lordship, very candidly, because I can't take objections apropos the jurisdiction of this court. Lordship, very candidly, I'll be putting this forth. Lordship, I filed my affidavit of assets. Lordship, there is a property within the jurisdiction of this court at Chittaranjan. Worth of around 50 lakh rupees, Your Lordship. Your Lordship, that is in the possession of the official liquidator with respect to another proceedings. Your Lordship, that if they want to take hold of that,
how will you take? How?
Because otherwise, Your Lordship, I do not have any means to satisfy the deed.
So remain inside.
Your Lordship, then Your Lordship, I need not embellish this court of judgments, but Jolly George Verghese, Your Lordship, knows that if I am not in a position to satisfy the decree, Your Lordship, to commit me to civil prison, Your Lordship, perhaps subject to correction, that would.
No, that is all right. Go and get it challenged and get that done. But before that, you have to be in.
My lord, apart from the defendant number 6 and 7, judgment debtors number 6 and 7, none of them have preferred any appeal. All of them have filed their respective written statements. My lord, these have been the ploy over and over again. They have been evading the court proceedings also. They erratically appear through the same set of advocates. I don't want to make any submissions on that, but nonetheless, the conduct had been very, very dubious and suspicious, my lord. Insofar as the defendants are concerned, my lord, the conduct had been very dubious.
Where are you staying now?
I have been all along in Bangladesh. That's the case made out in the plaint as well. The goods were to be transferred from India to Bangladesh to me. I never received those goods. That was my defense.
Good, bad, my lord. Today there is a decree staring at him. He cannot take the plea.
Right now. I am saying it can't be executed here, and my suits are already pending.
Your suits pending is nothing, neither here nor there.
This is prior in time. Those are prior in time.
That has got. That cannot be a defense.
I'm only
after the decree being crystallized, that is no defense.
If the execution is transferred in my jurisdiction where I am residing, I've disclosed the court.
No, my lord,
where I'm
in that case, my lord, I would also be entitled, my lord, to examine these judgment debtors before your lordship, my lord. In the event they say whether they have anything within or outside, that is also something which has to be examined.
If the assets are lying outside, then it will be executed through outside court.
But I am also outside.
Doesn't matter. You have filed your written statement. You have contested the suit, suffered a decree. You have never asked for dismissal of the suit.
I asked for stay of proceeding. That was allowed. That was allowed initially, and then for 8 weeks, then it was extended once. Thereafter,
they've chosen not to pursue with that particular application.
Even the decree has come. Forget. Those stages are over.
Because these are neither here nor there at this stage. Only thing I am saying is that because I am foreign nationals, and against a foreign national, my lord, whether a court
execution, I agree.
Execution,
if the properties are there finally, and the
is there, these persons are nowhere there in.
That's right. So that will come at the later stage. But first, I have to. He has to examine.
He has to first disclose at least any property which he can say.
Why? On him. Why?
Because I am saying I have nothing with
it.
You
are saying it is a sacrosanct.
No.
It will come from the box.
And whether an affidavit of asset in that respect has to be filed.
Who is not within the jurisdiction of this court will come without in connection with the execution proceeding. I am not adduce evidence in a court which otherwise does not have jurisdiction to deal with the execution proceeding because they are foreign nationals.
No, show me the law.
But they are foreign nationals.
Show me the law.
That was my initial submission.
Yes, show me the law.
Then kindly, not today, kindly take it up tomorrow or any day according to lordship convenience. I'll come with authority and law. I don't want to embarrass myself. In the first half also, the judgment did not come. Same problem will happen in this, I know. So kindly give me one opportunity. With all printouts and everything, I'll bring.
So nowadays, even the matters are also in the list. You are not ready.
I am factually ready, but the authorities have to.
That means you are not ready.
I am. I have given them, but the printouts have not.
So one day the list will be published, taken for granted, adjournment will be made, so that the you can come prepared on the next day.
I was told that they did not receive the affidavit in reply. So I thought, once readings are complete, only then the hearing will take place. But it's my mistake. So I'll.
So the point of law.
I'll place the code of civil procedure, whatever provisions I can show before your lordship, and then if lordship prima facie satisfied,
come on the next day, passed over for the day.
Kindly record that I have filed my reply in court. I have given them a copy today.
So you file করেছে নাকি?
I have just handed over to the
reply. এখন ফাইল করলো?
Just today, and I have served copy today in court.
এটা ফেরত দিয়ে দাও, পরের দিন নেব। কি তুমি কি কাটলে আবার?
Issued against him should be personally present today. Second time.
চলো আমি লিখে দিচ্ছি, কাটাকাটি করবে না, আমায় বলবে আগে লেখো। আসুন। This is an application for execution of a decree dated.
The decree was dated 15th of May 2024.
Huh?
15th of May
May 15,
2023.
2023. For a sum of rupees.
It was in US dollars, 4,28,500 US dollars. With interest.
US dollar,
4,28,500
28,000.
500
500.
Along with interest at the rate of 18%.
Along with interest mentioned in the decree. Full stop. Mr. Jayanto Sengupta, learned advocate, appearing for the decree holder, submits that the decree is equivalent to a sum of rupees
9,81,84,205.
981,84,205.
As on the date of filing of the execution.
As on the date of filing of the execution application. সবার অ্যাপিয়ারেন্স গুলো দিয়ে দেবে, কে কোন জাজমেন্ট ডেটার নাম্বার দিয়ে দিয়ে। ফুল স্টপ। মিস্টার Shoroshish Dasgupta, learned advocate, on the prayer of Mr. Shoroshish Dasgupta, learned advocate, appearing for the judgment data number
1, 2, and 3.
1, 2, 2, 3, comma, time to file affidavit in reply stands extended till today. Full stop. The reply filed in court today is taken on record. Full stop. Copy has been served upon the applicant in court today. Full stop. Mr. Dasgupta has taken the preliminary point of maintainability of this execution proceeding against his clients, comma, as his clients are resident of Bangladesh. Full stop. He submits that he prays for an adjournment and submits that on the next day he shall argue his point. He shall make his submissions. Paragraph. Accordingly, the matter shall appear under the heading Chamber Application for Final Disposal. On January 6, 2025. 2026. January 6, 2026.
Now, my lord, insofar as the other judgment debtors are concerned, my lord, the judgment debtor number 4 had surrendered himself. He ought to have been present today in court also.
Yesterday I recorded in my order.
Warrant was discharged, your lord.
Yes, I know. I have recorded in my order.
Yes, your lord.
Very well, very well, very well.
Only clarification, I am only seeking transfer in respect of these three defendants. I am not
these
three judgment debtors.
I've said that.
I am not clients. Not in respect.
Of course, I've said that.
Grateful.
Item number 6.
কি বললাম? As because ওটা কি বলেছি পড়ো? পড়ো not maintainable against his clients. against his clients. As
his clients are
public foreign nationals.
Item number 16.
Yes. My lord, in this matter, I am appearing on behalf of the degree holder. This is a period of service.
Lord, I am for the my lord judgment debtor, my lord.
এই মানে এই বোর্ডটাকে একটু আমার দিকেও ঘোরাও যাতে আমিও দেখতে পাই। বাস 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 ঠিক
Lord,
আছে।
in this matter, my lord, against the ex party, my lord, decree, my lord, I have already filed an order 9 rule 13 application for setting aside. And your lordship has taken up the matter on 10th of November and thereafter has been pleased to fix up this for final hearing on 12th of January. So, my lord, let it come.
No, in this matter, my lord, kindly see the order dated 8 September 2025, my lord.
The order,
my lord, the judgment dated was directed to file the affidavit of assets. Kindly look at it, my lord. Order dated 8 September 2025.
এই অর্ডারটা এখানে নেই কেন?
I annexed the order. I annexed.
এই অর্ডারটা দেখো তো 10th November
8th November 8 September.
এটা হচ্ছে অন্য মামলা, এটা অন্য অ্যাপ্লিকেশন।
This is a connected matter. Initially, all the three were appearing together.
This is an application for execution of decree.
Yes, my lord.
Full stop. The paragraph, the defendant judgment debtor has already filed an application for setting aside of an ex parte decree, comma, as the decree was ex parte against him. Full stop. The said application IAGA
2 and 3, my lord. One section.
Why 2?
There was a limitation issue also. One is for extension of time, another is for
the applications, the connected applications filed by the defendant being IAGA Com 2 and 3 of 2024 have already been directed to appear on January 12, 2026 under the heading Adjourn Motion by an order passed by this court dated November 10, 2024. Full stop. In view of the above, the present execution proceeding is adjourned sine die.
My lord, this is judgment dated was directed to file the affidavit of assets, my lord.
I am directing, don't worry.
Okay, my lord.
Adjourn sine die until the applications filed by the defendant are decided. Full stop, paragraph. However, the defendant, comma, without prejudice to its rights and contentions, shall file affidavit of assets.
Yes, my lord.
On or before January 7, 2025, 6, January 7, 2026, comma, upon copy being served on the learned advocate on record for the decree holder.
Yes, my lord.
Tell me.
I am assured.
Deeply obliged.
হ্যাঁ করুক না, যেখানে খুশি করুক না, ওই দিনের মধ্যে ওকে কপি দিয়ে দিলেও হবে, অ্যাডভান্স কপি দিয়ে দেবে, আমার পরে ফাইল করবে।
साहब दे मैं कॉपी हुई देता
I appear for the plaintiff.
You appear for?
I appear for the plaintiff.
What is the matter about?
Some suit for recovery of money on account of goods sold and delivered. In aid of the suit, there is a pending application, GACOM 7 of 2025. It is my application filed for judgment upon admission.
Affidavits exchanged?
Affidavit in opposition to my application has been given to us now.
Upon payment of cost.
Upon payment of cost pursuant to your lordship's last order of 10th November 2025.
What was the cost?
30,000 rupees, my lord, the cost? 30,000.
30,000.
Huh?
30,000.
Acha.
But we have paid the cost, my lord, within the stipulated period, my lord, and we have served the opposition also. We have affirmed it.
File a reply.
Yes, Lordship will kindly give me 7 days time to file the
Ashu.
reply.
Where is your affidavit?
My lord, the affidavit and the compliances under the Commercial Courts Act, my lord, on the last occasion, my lord, was not pleased to take it. But the compliances.
Ashu. Compliance also in the form of affidavit.
Yes, ma'am.
On the prayer of Mr.
Uttio Malik, my lord.
Uttio Mollik, learned advocate, appearing for the defendant. Time to file এটা করো IAGA কত জানো?
7.
ও 7টাই তো আছে লিস্টে। 7টাই তো আছে লিস্টে।
Yes.
কি বললাম? On the prayer of time to file affidavit in opposition stands extended till today, full stop. The affidavit in opposition filed in court is taken on record, full stop. Copy has been served upon the learned advocate on record for the plaintiff today in court, full stop. Paragraph. The plaintiff shall file affidavit in reply on or before December 16, 2025. The matter shall appear under the heading adjourn motion in the monthly list of January 2026.
Great.
Next.
Deeply obliged. Well, just one indulgence. Well, the cost has been paid.
It is recorded that the cost directed to Lekho Baba. It is recorded that cost Lekho na ekta line to it. It is recorded that the cost directed to be paid by this court has been paid.
Deeply obliged.
Item number 18. My lord, my application, my lord, is essentially, my lord, for judgment upon admission.
দাও আগে এই যেটা লাস্ট দিলাম যেখানে খুশি ঢুকিয়ে দাও। Yes. ঠিক আছে। Yes.
Yes, my lord.
Application for
Judgment
কাগজ আগে তুলো না।
Judgment upon admission, my lord.
পক্ষ নেই তো।
My lord, on the
affidavit filed.
Affidavits exchanged, my lord. Affidavits, I need to be candid, my lord. This matter.
Opposition filed.
Opposition, my lord, insofar as, my lord, the defendant number 1 is concerned, the respondent number 1, he has filed the opposition, my lord. Now, the matter, my lord, pertaining to their application for deletion of their name, that matter had appeared yesterday, my lord, where CIRP had commenced. Now, my lord, naturally, now they are not proceeding with this.
So RP must come.
RP must come, but my lord, as on this date, they have not taken any steps. Now, my lord, there are other defendants, respondents as well, my lord. Against it's a joint and several claim, my lord, insofar as the area of defendants are concerned, my lord. Now, the issue over here is, I'll just give it in a nutshell, my lord, because
what is the use in their absence?
My lord, the difficulty is there had been services affected upon the rest of the defendants. They have chosen not to appear. Now, my lord, perhaps at that.
If they have chosen not to appear, they have not filed affidavit in opposition.
No.
So it will be ex parte against them. But the party who has filed opposition, he has gone before.
He suffered CIRP. Well, substantial claim, my lord, insofar as the rest of the defendants.
Mr. Jayanto Sengupta, Learned Counsel, appears for the plaintiff. Paragraph. None appears for the defendants. How many?
My lord, there are 6 defendants.
All right.
I'm sorry, my lord, 7 defendants.
Full stop. Paragraph. This is an application, comma, inter alia, comma, praying for judgment upon admission. Praying for a judgment upon admission. The suit is for price of goods sold and delivered.
Payment not made.
Paragraph. Mr. Shengupta informs this court that only the defendant number 1 has filed its affidavit in opposition, to which plaintiff has filed affidavit in reply. Rest of the defendants chose neither to be represented nor have filed affidavit in opposition, comma, despite notice. Paragraph. The defendant number 1 has undergone an insolvency proceeding under IBC. Resolution professional has been appointed.
But my lord, there's one more thing, my lord. We have not been formally communicated regarding this.
Informs, I said. আচ্ছা ঠিক আছে ওকে একটু প্রোটেকশন দিয়ে দিই কি বলছেন Mr. Shengupta submits that the plaintiff has gathered information. Gathered information that না না ওইখানে না ওইসব জায়গায় কোনো গ্যাদার্ড নেই ওটা তো একদম রেকর্ড ওখানে যা ছিল ব্যাস only the defendant number 1 ওইখানে কিছু গ্যাদার্ড ফ্যাদার্ড না হ্যাঁ informs this court ওই অবধি থাকবে ওটা ঠিক আছে Mr. Shengupta informs this court that only defendant number 1 বলে যা বলেছি এবার নেক্সট প্যারাগ্রাফ লেখো Mr. Shengupta further submits that the plaintiff, singular or plural?
That's singular.
Plaintiff has received information.
My lord, received, rather derived, my lord. It's not received. We have not received any formal communication.
Gathered. Information that the defendant number 1 has undergone a insolvency proceeding. Has undergone in an insolvency proceeding under IBC. Full stop. Resolution professional has been appointed. Comma. Who must step into the shoe of the defendant number 1 in this proceeding. Paragraph. In such circumstance, comma, in the event the plaintiff receives complete information then the plaintiff shall serve a notice upon the concerned resolution professional. One second, are you a party in the CLB? Concerned resolution professional and also upon the defendant number 1 at its address mentioned in the plaint and shall file an affidavit of service on the next day. Full stop. On the next day, the plaintiff shall apprise this court with the detailed informations with regard to the present status of the defendant number 1. Paragraph. Other one কবে করে রেখেছি
That is sometime in February, but my lord, I want to, insofar as the rest of the defendants are concerned, my lord, I would like to proceed against them.
Your claim is joint and several.
Yes,
So,
but at this juncture, my lord, I cannot proceed.
First, take this step. Tell me, when have I kept that?
My lord, perhaps in February, my lord.
Monthly list?
Not very sure, my lord. The order was passed yesterday only. Yesterday.
Very well. This application?
I think February. My lord, I'm told, my lord, it was on, has been fixed on 19th of February, my lord.
This application shall appear on February 19, 2026, under the heading adjourned motion. On that day, when you remind me those two?
My lord, there's only one thing, if I may humbly beseech your lordship, my lord.
Acha, the plaintiff shall serve a copy of today's order upon the non-appearing respondents also, once again, and file affidavit of service.
My lord, the issue over here is you have served them thrice. Now, my lord, they have chosen not to.
I have kept it after 2 months, so do one, make one more service.
Very well, my lord.
Because your claim must be framed in the suit in a joint and for a joint and several decree. So how this can be segregated at this stage?
My lord, perhaps I would have liked, my lord, to proceed in respect of the rest of the defendants, because in any event, my lord, I wouldn't be able to proceed insofar as the defendant number 1 is concerned.
Mr. Counsel, go and serve on the RP. You will get you will get your own answer there.
I understand what falls from your lordship, my lord.
After all, some practical experience I have. Why do you forget that?
No, absolutely. I have been
on this branch for 22 years.
Absolutely. But my lord, this is the.
Go and serve.
I will.
You will get the reply from him.
Very good.
Not to file, nor to file, neither to be represented, nor to file affidavit in opposition. হ্যাঁ না অপোজিশন ওটা তো ওর দরখাস্ত ডিগ্রি চাইছে ঠিক আছে চলো কমা ডিসপাইট নোটিস
Grateful.
Item number 19, item number 20.
My application, my lord, under section 10 of the. This is my application, my lord, under section 10 of the Code of Civil Procedure, my lord, seeking stay of the suit, my lord.
Parties are same.
Parties are the same.
According to you, issues are same.
Yes, my lord.
I mean identical.
Yes, my lord.
Show me.
My lord.
Give me both the two plaints.
My lord, there was a direction, my lord, for affidavits to be filed, my lord. That has not been completed.
I can't hear you.
My lord, there was a direction for affidavits to be filed, my lord. That has not been completed yet, my lord.
Which one is not completed?
My lord, the affidavit in opposition has not been received yet. My lord, the opposition, my lord. Affidavit in opposition, my lord.
Finally, I got a chance to say.
Huh?
Finally, I got a chance to say, my lord, I could not file it within time. Kindly extend me for another 7 days.
Mr. Shayak Mitra, learned counsel, learned advocate, appearing for the
My lord, defendant, my lord. The defendant, my lord. Sole defendant.
Sole defendant.
Yes, my lord.
In both the suits.
No, yes, my lord. This is one suit over here, my lord, that is appearing today. And the other suit, my lord, is a suit in the City Civil Court, my lord.
Doesn't matter, but it's all 1:1.
Yes, my
Sole
lord.
plaintiff,
Yes, my
sole
lord. Yes,
defendant.
my
Both the suits.
Yes, my lord.
কি বললাম? In TSCOM number?
My lord.
196 of 2022.
Number 419 of 2024.
No, this suit.
Yes, my lord. This is 419 of 2024, my lord.
TSCOM number কোথায় রে বাবা 19 and 20 তো দেখাচ্ছে 196
My lord, that is the old number, my lord.
ও আচ্ছা
Now
আচ্ছা
CSCOM is
ঠিক
490.
কি বললাম কি বললাম appearing for the defendant in the instant suit being CSCOM 4 of 419.
Yes,
CSCOM 419 of 2024 submits that this is an application filed inter alia under section 10 of Code of Civil Procedure, praying for stay of the subsequent suit.
My lord, of this suit, my lord.
Oh, praying for the instant suit. Right. Otherwise, how will you apply? Instant suit, comma, as the instant suit is the subsequent suit and the prior suit is already pending before the learned city civil court between the parties.
Filed by
being-
them. Filed
That
by the
was filed by
defendant.
me. That-
Filed by the defendant.
Yes, my lord.
He filed two suits against me. He filed two suits against me so that I should not initiate any action against him. He was a monthly tenant and
Doesn't matter. I'm not on cause of action.
he filed two suits against me.
Then why if you file two suits, then why will you apply for stay of this suit?
My lord, may I, my lord, this is with regard to the issue in this cause,
No,
my
let
lord,
me
the
see
cause
the
of action that has
Take it.
arisen, my lord.
Why you are saying you are for the defendant?
My lord, in this suit, my lord.
And in city civil court, he is the plaintiff.
My lord takes paragraph 9 of my application, my lord. G5.
The language is instituted substantially in issue in a previously instituted suit between the same parties, not by the same plaintiff. So it's possible. Yes. কি বললাম?
No, sir.
Before
আমার পড়ো Mr. Mitro, learned counsel, advocate appearing for the your defendant here.
Yes, yes.
Appearing for the defendant, পড়ো. CPC, praying for stay of the instant suit as a previous suit.
two previous.
Two previous
Yes.
suits.
My lord,
Kindly see paragraph 9 and 15.
Yes, Mr. Mitro.
yes, my lord.
Two previous suits.
Yes, my lord. Paragraph 9 and 15, my lord, that it is mentioned, my lord.
Two previous suits filed by you.
My lord, by me.
By him.
Them.
Yes, my lord.
Acha, in city civil court.
And kindly see the prayer is set out. Paragraph 9 and paragraph 15. The tenant in my property did not leave the property. Government property.
Paragraph 9.
Yes.
my lord.
First
That
suit is
page
paragraph
5.
9 and second suit is paragraph 15.
First suit, where is the number? Paragraph 9.
Lordship, it is given.
Page 9.
819. Yes,
GA5.
GA5. Lordship, kindly take GA5, page 5. Kindly see the declaration prayer.
Next one.
Paragraph then 11.
Then
My lord,
15.
15, my lord, at page
9 and
8, my
15.
lord.
Yes, these two he filed. And then kindly see my prayer.
Then
Kindly prayer of my suit. If three prayer are similar, then Lordship can.
and that is on affidavit.
No, I will be praying. Previously, could not pray when the direction for affidavit was given. I will only beseech your Lordship to record that maintainability of the application may be kept. Yes, ma'am.
কি বললাম? The previous two suits being title suit number 819 of 2017, 819 of 2017 and 532, so title suit number 532 of 2020 between the same parties. Now, filed by his client are pending before the learned city civil court. পড়ো তো একবার। And the parties in the three suits are same. And the cause of actions are
Cause of action different, but the property is same. Subject
the
property is
cause of action,
same,
my lord,
party
is
is the
also-
same. Has to be cause of action different. He filed two different suit, two different time. Timeline of filing suit is different, so must be cause of action different. Otherwise, it will be barred.
My lord, the
Order
case that
2,
is-
rule 2.
and according to him, the issues are interconnected. Paragraph. Mr. Shiv Shankar Banerjee, learned counsel, learned advocate appearing for the plaintiff in the instant suit, has denied and disputed the submissions of Mr. Mitro. Full stop. He has raised the point of maintainability of this application. Full stop. Paragraph. Mr. Banerjee has prayed for an extension of time to file his client's affidavit in opposition. Paragraph. Time to file affidavit in opposition stands extended till December 8, 2025. Affidavit in reply by December 23, 2025. Paragraph. The matter shall appear under the heading adjourn motion. Now, Tapal Lekho. The point of maintainability shall be heard first. Paragraph. The matter shall appear under the heading adjourn motion in the monthly list of February 2026.
Can keep it January. By December, we are completing the pleading. Lordship can keep it in January, Lordship.
Yes, January Burani? Oh, I'm so sorry. So sorry. My mistake. Wait. Huh.
I'm declared for
It's pending there. Will they be covered
my lord.
within the
affidavit of
expression of
service and the notice of motion, my lord, are
within the expression
the
used
issue that arises, my lord, is that the
within,
second
take
suit,
the microphone.
my lord, the
Within
second
the meaning and expression used under section 10?
my lord, the issue that arises, my lord, is that the second suit challenges the letter that is the cause of action for this suit, my lord. My lord, the issue in that would be whether the letter dated 12th of June 2020 would be legal or, my lord, would be valid or not.
Ultimately, you are challenging an eviction notice.
Yes, my lord. My lord, if that eviction notice is declared to be void, my lord, this suit, my lord, does
in a
not.
public premises.
Yes, my lord. My lord, this suit does not lie, my lord, in this.
In a public premises.
My lord, that issue, my lord, has already been considered at this point, my lord.
All right.
I was just thinking in a different way.
My lord,
The
the affidavit of
notice.
service and the notice of,
আচ্ছা মাথার উপর affidavit of service filed in court
and the
today.
notice of motion, my lord.
Affidavit of service and the notice of motion filed in court today are taken on record.
Grateful, my lord.
Because every day is a new cause of action for so far as eviction.
No, that is a different. All right. Come on that.
I'm devious.
I'm appearing
I appear for the plaintiff. These are
for the respondent.
but
Impressed
GH3
time today.
Passed over for the day.
Grateful, my lord.
My lord, I am appearing for defendant number 2.
You're for?
Defendant number 2, my lord.
Passed over.
Number 27 and item number 20. Item number 29. Item number
তাড়াতাড়ি দাও.
item number 34. Item number 35. Item number 36.
Item number 35, I am for the plaintiff.
Item number 37. Item number 38. Item number 39. Item number 40. Item number 41. Item number 42. Item number 43. Item number 44. Item number 45. Item number 43. Item number 47. Item number 48. Item number 49. Item number 50. Item number
50 তো ডাকার দরকার নেই, ওটা তো কালকে স্যুট তো কালকে।
Item 48, it's not been called yet.
That is called out. কালকে যে জাজমেন্টটা সার্ভার হলো ঢুকিয়ে দিয়েছো তো?